Hello, good morning. It's another Saturday, and you're welcome to The Big Issue, coming to you live from our studio here in Accra. Big Issue is also live on City 97.3 FM. This week have been very interesting one, if you ask me. A number of issues have dominated media discussion across the country. If you're aware, the suspended Chief Justice, Madam Gertrude Torkornoo, addressed a press conference this week to outline what she believes are some infractions and unconstitutional acts currently underway as far as the proceedings to seek her removal is concerned. A press conference or a news conference many people have raised issues with, that a whole Chief Justice may be addressing, the public when there was a right forum for her to, express her grievances in this matter. We'll discuss this particular issue as well. And also, the national chairman of the National Democratic Congress, or the governing NDC, has made some comments in respect of what's happening at the Electoral Commission. Now, he says that maybe, possibly, the three chairpersons of the Electoral Commission, Madam Jane Mensah and her two deputies, may be removed. It has to do with what he described as incompetence at the running of the country's electoral body, which is the Electoral Commission. We'll also have a discussion on this issue as well. And also, the opposition New Patriotic Party is in the news. The party is preparing to elect a new flag bearer for the party as it prepares for the 2028 general elections. A number of issues have come up, a number of people have declared their intent, but then the worry is about the campaigning or what is going on in the party. A lot of people have raised concerns. For instance, former President John Agyekum Kufuor is worried about what he describes as the religious politics or the religious campaigning within the MPP, which he believes his care is not taken, may make the MPP stay in opposition for a long while. So these are the three issues we are discussing today on The Big Issue, coming to you live from our studio here in Accra, live on City 97.3 FM. We'll go for a quick break. When we come back, I'll introduce my guest and we'll start the discussion. Hello, you're welcome back. This is The Big Issue, coming to you live from our studio here in Accra. It's also live on the City 97.3 FM. As I told you earlier before we went to the break, there are three issues on the table that we are discussing. The Chief Justice addressed a press conference this week to more or less bring to light what she believes are some infractions and some unconstitutional acts within the processes that is seeking to remove her from office. Also, the national chairman of the NDC, Johnson Esedun Ketia, said that there is the need to have a leadership change at the Electoral Commission because he described the three leaders there, which is the chairperson and her two deputies, as incompetent as far as the management of the election body is concerned. The New Patriotic Party is also in the news again. If you're aware, the party is preparing to elect a new flag bearer ahead of the 2028 general election. So the Chief Justice addressed a press conference this week, and she's not happy with what she says is the current processes seeking her removal from office. She says these activities are a breach of the 1992 Constitution and want all meaning Ghanaians to rise and speak up. Let's listen to the Madam Chief Justice at this particular press conference that she held on Wednesday.
Suspended Chief Justice Gertrude Torkornoo says the move to remove her from office undermines the Constitution and threatens the independence of the judiciary. Speaking at a press conference, she explained her decision to speak out publicly, citing four key reasons: the historic nature of the case, its implications for other constitutional office holders, rising legal irregularities, and pressured her to step aside. Justice Torkornoo also revealed that her legal team has filed for a judicial review at the High Court, aiming to halt the ongoing process. She claims the proceedings led by the Justice for One Committee have been marked by procedural lapses. Among her concerns are her legal counsel was allegedly ignored on the opening day because she wasn't physically present, even though her lawyer was in attendance. She says subsequent hearing dates and decisions were made without her legal team's input. She also raised red flags over the committee's decision to excuse two petitioners, Daniel Ofori and the group Shining Stars, from testifying, which she argues denies her right to cross-examine them.
The committee has gone on to permit two of the petitioners, Mr. Daniel Ofori and Shining Stars, not to testify at all or present what case they brought to them at the hearing. The committee has refused to allow me to go into the hearing with any family member.
Another key concern is the venue. hearings are being held in a restricted area on Castle Drive in Osu, rather than a judicial facility. She believes the location and the closed-door nature of proceedings create an atmosphere of intimidation.
He was my uncle and my guardian when I entered the University of Ghana in September 1980. I was also living with him at the time he was abducted and murdered. Was Edu Lodge chosen for my inquiry to make me feel insecure? I think so. And I continue to hold the view that there's no reason why a judicial hearing is being conducted behind the high walls of Edu Lodge.
Suspended Chief Justice Gertrude.
That was suspended Chief Justice Madam Gertrude Torkornoo. If you're aware, on Wednesday, she addressed a press conference to more or less bring to light what she believes are some unconstitutional activities happening as far as her removal process is concerned. That report was filed by my colleague, Hansen Ajima. We'll start the discussion, but before that, let me introduce my guest for today. Hamza Suhini is a member of the NDC communications team. Richard Ahiagba is the Director of Communications for the New Patriotic Party, the NPP. We also have Andrew Apia Dankwa, spokesperson for Movement for Change. And as usual, we'll have Franklin Kujo, the president of Imani Africa, also joining us for this discussion. If you're aware, this week as well, the same press conference held by the Chief Justice, the government reacted. Immediately after the Chief Justice held a press conference, the government spokesperson or the Minister of State in charge of Government Communication, Felix Kwachiofor, also addressed a press conference saying that the government has no intention as far as the illegality is concerned. They say that the law is at work and that the procedure that is currently underway is what the Constitution dictates.
Raising concerns over what she terms as a clear violation of the rule of law, the Chief Justice has leveled serious allegations against the process aimed at her removal, describing it as a calculated effort designed to oust her. But government spokesperson Felix Kwachiofor has dismissed the claims, insisting that the president has acted in full accordance with the Constitution since the process commenced.
All those who have commented on the matter, including her leadership, the Chief Justice, have been unable to point to any specific provision under Article 146 that the president has been in breach of. Her leadership, the Chief Justice, all but insinuated that there was some political agenda at play to oust her, and that this whole process is a result of sin. Let me place on record, without fear of contradiction, and let me be clear that no such political agenda exists.
The government defended the use of the Edu Lodge site, long associated with the dark chapter of Ghana's history involving the abduction and murder of 3 High Court judges, as the venue for the Chief Justice's hearings.
Yes, it is close to the Osu Castle, which used to be the former seat of government. As I speak, there are government agencies that operate there, so it is a public place. The Osu Castle is a public place. You can go there to conduct official government business. Beside it are private residences owned by Ghanaians who move freely in and out of their residence, even though they are situated very close to the Osu Castle. So the impression that a facility in the vicinity of the Osu Castle necessarily makes it intimidating or foreboding is completely misplaced. It is unfair. It is not justifiable. Now, Edu Lodge is a state facility which is often used to house high-ranking officials who visit the Republic of Ghana. It belongs to the state. The decision to use that place was not that of government or President Mahama. The committee requested that they needed facilities of a certain status that could house their activities and that could facilitate a smooth running of the proceedings.
The spokesperson also notes the government welcomes the Chief Justice's decision to seek judicial review at the High Court.
If the law says that this process must be held in camera, the president has no choice than to act in ways that respect this. And I believe the committee is also respecting it at this. Indeed, the Constitution does not allow for commentary on the substance of the allegations, she is entitled to do so, and we encourage her to avail herself of any opportunity there is to vindicate her rights.
Phyllis Kwachufo is government spokesperson, Minister of State in charge of government communication. We'll start the discussion, but before that, you can join us with your WhatsApp messages, 020-444-7033. I repeat the number 020-444-7033, or the number is displayed on your screen. You can WhatsApp us with your thoughts and your comments on the topics we are discussing today on the big issue. I'll start with Richard Hiangba. He's the Director of Communications for the MPP. If you're aware, the MPP has been the one, more or less talking about this whole CJ removal and how the process has been so far. Richard, welcome. Thank you very much for your time.
Thank you, Sammy.
Well, I'm sure you listened to the press conference on Wednesday. What are your general impressions?
Well, Sammy, good morning, and good morning to my good brother, who I'm happy to see, except that there are matters to talk about after the program.
Private issues.
No, related public matters. And our other colleagues will join us. I hear Franklin will join us, Hamza
too,
and others. Well, this Chief Justice matter. The NDC will go down in history as the most oppressive, judicial oppressive regime. One that took our judiciary over, subjugated it, if they conclude this process, and therefore appoint Chief Justice to replace Madame Gertrude Torkornoo. It's unheard of that a president would go as far as they are seeking to go in the absence of a very compelling, clear-cut evidence of misconduct, incapacity to perform or execute the task of the office of Chief Justice, to want to remove a Chief Justice.
But they are working on a petition. A petition was presented.
That's as flimsy as the word flimsy. The things they put together, they cobble together to remove a Chief Justice. It's as flimsy as you can imagine. There's no basis for that. We shouldn't be having this conversation. We're toying with our democracy. You understand? And so the NDC will go down as that political party whose government took drastic effort to undermine the balance of power in our country. And that is pushing us close to the precipice, to the point where citizens, our rights, will be taken for granted. If you look at the things the Chief Justice has enumerated, unfortunately I've heard some very seasoned lawyers casting insinuations and trying to create the impression that she doesn't have her facts, or that she doesn't know what she's talking about, the application of the law and matters, as though that she doesn't know what she's talking about, that she's a lawyer of yesterday. It's not right. Look, Article 127.3 talks about the liability of a judge in his or her exercise of judicial power. That is not something a judge should suffer because you exercise your power in dispensing justice. But what Chief Justice Torkornoo is suffering, one of the cardinal matters there, is because an individual finds out or says that, I don't like your ruling. I don't like a situation where you exercise judicial power to keep order or to bring order in a courtroom when an individual is acting unruly. It's beyond my imagination how that is a basis to remove a judge. The matters that have been outlined in most of the petitions, they are right here. They are at best administrative matters that must be dealt with. And as we speak, there isn't any. And you know, the Auditor General's office is independent, constitutional body that is not subject to the judiciary in terms of the execution of their task. So therefore, if they come to audit the judiciary and they find impropriety, they must cite it.
Yeah.
But they have not cited her for anything related to the expenditure that has become a matter for petition. So I'm just wondering what this is about. I'm wondering what is going on. What is this about? Taking on the Chief Justice simply because of what? But I submit to you because, we've demonstrated about this and we are clear in our mind it's nothing to do with Justice Torkornoo. It's about the office, the sanctity of the balance of power, the setup of our democracy, to make it remain what it is, to hold each one accountable, the three accountable, so that our democracy will run smoothly. We demonstrated to say that this is not right. And we are not alone. We are not alone, except that the government is determined, full steam ahead, to remove the Chief Justice, so they won't listen to anybody.
But Richard, what is not right about it? Because they are going according to the dictates of the Constitution.
Forget about the dictates.
Hold on.
Yeah.
And the Constitution makes a provision for how a Chief Justice is removed. And you heard the government spokesperson say that there's nowhere has the Constitution been breached as far as this whole process is concerned.
So are you suggesting that Phyllis should come there and say the Constitution is being breached?
No, I'm not saying so.
Quoting her is a non-starter.
So, but then he said there's no way.
Is an interested party in a matter seeking to move full steam ahead to remove the Chief Justice. I just quoted Article 127.3 to you, where a judge exercises a certain power given to her in dispensing justice. And an individual says that because that action was taken, he's not happy. And
you think the committee members do not know about this provision that you quoted, and yet they went ahead to do their work as directed by the Constitution?
So you are trying to tell me?
I'm asking questions.
But you must ask questions that are within the bounds of reasonability. That question you're asking, is not a reasonable question.
How is it not a reasonable question?
The point is that it is expressed, black and white.
Why is it not reasonable?
Wait, it's black and white. Mm-hmm. The same Constitution they are saying that Constitution said the proceedings to be held in camera says that you shouldn't subject a judge to any inquiry or to any liability, or she shouldn't be liability. He or she should be liable for any action in the process of exercising judicial power. But here is a petition that is put before a committee, a petition on the strength of which a prima facie case has been determined that somebody should come and answer why they exercise the judicial power to bring order in the courtroom. And you are saying that that is kosher? You are saying that's consistent with the Constitution? She raises matters to do with the process of inquiry, where the committee indicated that they are not going to use processes that are known to be applicable to committees of inquiries. They are going to use certain approaches that in their very nature are more of an adversarial litigation rather than an inquiry. The processes that she outlined, that she herself, subject to separate and different treatment, coming before the committee, and the petitioners who have the burden of proof in the allegations that they have brought, or the petition that they brought against her, are rather being laid red carpet for. That they bring all the facilitations they have. They are picking and choosing what they want to do. They themselves will not testify. But everybody else will testify to something they have not testified to. They have not shown any, they have not been cross-examined. They just bring fact that, I'm not happy with the way Chief Justice Torkornoo has been dispensing justice, so please remove her. Is that what we want to do in our country with a view that we want to grow our democracy? Certainly that's not. So when you quote for me my good brother Felix Kwachi, you are rather just telling me that I should sing his song and say that everything is nice.
I'm not asking you to sing his song, Richard.
Because my view is that beyond what your politics is, beyond what your politics is, if we must say that let's not allow Sammy Wiafe to host this program or step in, then the basis must be such that Sammy has not hosted any program in this ChannelOne place before. So therefore, he doesn't have capacity to do it. Sami is better at other things, but not hosting this program. Chief Justice, there is no evidence whatsoever that she is incapable at all. That none whatsoever. Her 38-year record combined has not shown any evidence of incapacitation or lack of competence at all. So that as a country, we say that that Chief Justice is incompetent. And so we don't want her to be Chief Justice. Everybody in this room can come into some agreement and say, Sami is just not simply good. So if somebody says you shouldn't host a program, it's not as if they are picking on Sami, it's just that he can't do it. Even if you give him all the facilitation, he simply can't do it. On that basis, if you move to remove a Chief Justice, we will canvass for you to do it quickly and fast. But where we are, they are nitpicking. They are picking on the Chief Justice. And I'm saying this completely devoid of my politics. I'm afraid for Ghana. Because the precedent that is being set, not only would other people look upon it to act tomorrow, but it will go down. And I agree perfectly with the Chief Justice that other independent constitutional bodies can be singled out for this kinds of treatment. So why give us this very terrible precedent? Why give us this precedent? That some bad people tomorrow, some bad individual, some bad leader comes and says, but all of these things have been possible before. Why not? Why not take the step further? Because you build on the foundations you inherit.
Okay.
So therefore, what we are seeing, for me, is unpatriotic. It is completely whatsoever needless. There is no way in my life I should imagine, or we in our life as a country, should we imagine any president attempting this. It's not possible. We shouldn't condone this. Okay. That's why the Ghana Bar Association is against it. We are not alone in this matter. The Commonwealth Lawyers Association are against it. We are not alone in this. Every Ghanaian, the issue put properly, devoid of passion and politics, will see clearly that what you are doing is not right. Okay, there are individuals who have used public funds for things. Yes, I mean, 1 minute is even too much, right? Who have used public funds to do things where they were found to have done so inappropriately. Audit cited them, they were surcharged, and they moved on. Now, they say, as for Chief Justice, the matters that has come in relation to a husband traveling with her, daughter traveling with her, and some per diems were paid, that is so egregious that it's never happened. That everything we have been seeing at the Public Account Committee being told us, the millions that have been misappropriated in cases of public administration and expenditure, those are just movies we are looking at. They're not happening in this country. Okay. Such that when the Chief Justice... just less than that. Finally, just to try and land for you. Such that when there is that perception that, okay, well, some expenditure has been made on behalf of the Chief Justice, which she didn't dispense herself, is found to be out of alignment with what is applicable to her, she is removed rather than the processes. And by the way, there is no record of her being surcharged by the Auditor General. Okay. So I'm asked the question, what is this whole thing about?
Thank you. Thank you very much. Let me also introduce Hamza Suhini. He's a member of the NDP to also help us with the discussion. I'll go to him because this a matter that's related to his government, or will I say a member of the government, I should say. Hamza, Richard is of the view that this whole process is unpatriotic and is a bad precedent. And if we encourage it, other Chief Justices may suffer same.
Good morning to Richard and my senior at the bar, and of course to your very good self and our cherished viewers out there and listeners out there. Sami, I think that it is important to situate today's discussion. I have listened to Richard, and this is not my first time of listening to him on this matter, and that of the New Patriotic Party. And I am struggling to understand what they truly stand for as a political party in this particular matter. You see, this might appear historic, but when it comes to the application of Article 146 of the 1992 Constitution, this is not the first time it has been invoked. And my senior Apia Dankwa would agree with me that those who attempted to use it on the pillars of our democracy for the first time was the New Patriotic Party. Indeed, it was Richard Nyama and Honorable Arnold Dampre who first petitioned President John Dramani Mahama using Article 146 for the removal of Mrs. Loretta Lamte as Commissioner of the Commission on Human Rights and Administrative Justice, Chiraj. At the time they were doing so, didn't they know the implications such an action would eventually have on other institutions of state? That falls clearly under Article 146. Didn't they know as a political party? Were they subjecting our democracy to danger? They did not stop there. They proceeded to invoke same Article 146 and demanded the removal from office of Mrs. Charlotte Osei. She was taken through the processes and removed in a similar fashion by His Excellency Nana Addo Dankwa Akufo-Addo's regime, of which my brother, as Director of Communications of the NPP, spoke in defense of. At the time he was speaking, defending the Charlotte Osei removal process, didn't he know that such an action could pose a serious danger to our democratic stability, especially when the Electoral Commission of our republic is actually the anchor of the 4 pillars of government, if you like, that is adding the media as the 4th estate. Because without a credible Electoral Commission, you cannot realize the dreams of our democracy. Because you would not be able to elect an executive, you would not be able to elect the legislature, and you would not be able to have in place a working judiciary. So that tells you the importance of Electoral Commission and the commissioners when it comes to the stability of our democracy. Didn't my brother in the MPP know that? But I believe they argued forcefully that they were acting in tandem with the dictates of Article 146. Remember, that was when that popular phrase that the president is acting as a conveyor belt came in. So what has changed? Why these double standards? Even when we're pointing to apparent breaches of the process, they told us to shut up. And mind you, it was not the National Democratic Congress alone that rose against that action. Today, in the case of the Chief Justice, it is the MPP that is leading the charge. They are those making the noise. Who else is speaking? So they think that their views on this matter supersedes that of every legitimate Ghanaian out there. These are the questions we should be asking, Sammy. And for us, look, they must thank God that His Excellency President John Dramani Mahama is president today and does not have an iota of the character trait of His Excellency Nana Addo Dankwa Akufo-Addo. The same President Mahama, in his first term, we had petitions filed against the then Chief Justice, Madam Georgina Woods, to the extent that a former retired Supreme Court judge, Justice Pega, filed a petition for her removal. We know how the NDC suffered in the hands of Madam Georgina Woods. Indeed, it was under her that one of our leading members, most celebrated, revered in the politics of the NDC, and to a very large extent, our national political space, the revered Chachu Chikata, was incarcerated. And remember the injustice that characterized his incarceration. So the MDC was a wounded party in opposition. And many of our supporters called for the removal of the Chief Justice. It was the most painful experience since 1992 for the National Democratic Congress. But even with that, when President Mahama eventually received a petition, not just from any ordinary Ghanaian, but even a member of the bench, Justice Klega, President Mahama looked at the petition in consultation with the Council of State and declared that those petitions did not have merit and threw it out. So if today you have the same President John Dramani Mahama, who has received petitions, not one, not two, about 3 or 4, from well-meaning Ghanaians, demanding the removal of the current Chief Justice, now suspended. And the same president proceeds on the basis of that to, in consultation with the Council of State, to institute, to find a prima facie determination and say we should proceed.
How's that? The argument is that these petitions are not, the substance in these petitions are not really anything.
You see, it is not, the Constitution did not say that myself and you should determine the substance or otherwise of those petitions.
But sometimes you need to consider the kind of misconduct or allegations
you
in
see,
there
that is
before you can take a course of action.
But you see, that is not for you to make. It is for His Excellency the President in consultation with the Council of State. So you want us to sit in this chair and pretend that the President in consultation with the Council of State, we are not dealing with one member of the Council of State. Collectively, we are smarter than them. And that looking at the petitions, we cannot see grounds for the establishment of a prima facie case. And so the fact that they have seen it means they are wrong. We are that brighter than them. Is that the conclusion on this table? Do we know what facts are available to the President and to the Council of State because of their privileged position? And how they can quickly, based on what you deem as mere allegations, because remember the Constitution says that it must be in camera, the process must be protected. Based on what you call as what you call mere allegations, do you know that maybe the Presidency in consultation with the Council of State have looked at it, decided to dig a little bit further to see whether some of them have substance? That's the essence of prima facie determination. You are not privileged to have that information. You don't have that luxury of state authority. They do. And they have come to such a conclusion. And you say that on the basis of the fact that these are mere allegations, it is not enough to establish a prima facie determination. Some I disagree. Again, when it comes to the delivery of justice, there is nothing like mere, because the lives of everyday Ghanaian depends on it. And I had cause to make the same point some weeks ago on this same platform, that allegations that might not be sufficient to remove you, Sammy, from hosting this program. When it comes to our justice delivery system, because of how sensitive it is, might be enough to remove a Chief Justice. Because we cannot gamble with our judiciary. So what do you consider mere that you can get away from as the host of this program might be the basis of taking out a Chief Justice? Because if we make the mistake and brand it as mere, it could lead to somebody being denied of his personal freedoms because of that mere allegation. That is why we cannot take it lightly. So these are the facts. President John Dramani Mahama has done absolutely nothing wrong as far as these processes are concerned. And I am yet to hear even the MPP point out what they consider a breach of our Constitution as far as the President's actions are concerned. They have not been able to point out one. What they have been engaged in the words of the former, the suspended Chief Justice, is to blah, blah noise out of their system without any substantial basis of engagement when it comes to the legalities. These are the facts. Now, to the press conference of the suspended Chief Justice. Sammy, that is another interesting one. First of all, I think that Madam Araba Torkornoo.
In 5 minutes.
Oh, but that is the meat of the discussion.
In 5 minutes. You had enough time, but you were having a prayer mood
listen
before.
to him, I beg you, Sammy. No, 5 minutes will not be fair enough. You see, because this is the essence of, you see, listening to her, for the first time, I came to the conclusion that she had taken a conscious decision to go rogue as far as this matter is concerned. And in that action, she consciously chose to desecrate the Constitution of the Republic of Ghana, our judicial architecture, and finally, openly dared the presidency of the Republic of Ghana, which is also another constitutional creation. And I'll explain why. I say that he has desecrated the Constitution of the Republic of Ghana. You questioned the motive behind holding the proceedings in camera and proceeded on the basis of that to file an application at the Supreme Court demanding that the proceedings be made public. In addition to that, you requested that your human rights were under threat and being violated by the committee. That was what the supplementary affidavit sought to do, not so senior. Now, despite the fact that you are a judge of the Supreme Court and ought to know that there are a litany of cases that already laid down the rationale behind holding such proceedings in camera. You are at liberty to disagree and to call for the Supreme Court to have a review. You did so. The Supreme Court looked at your matter and decided that there was no constitutional basis for such a call, and you did not have that right, and threw you out. And they just didn't throw that out. They also proceeded to strike out your supplementary affidavit that pointed to human rights violations on the basis that entertaining it would constitute a breach of Article 146, Clause 8 of the 1992 Constitution that demanded that the process should be made in camera. This is the ruling of your colleagues. In her press conference. So the essence of the ruling was to protect the in-camera proceedings as enshrined in Article 1468. You hold a press conference and you proceed to discuss the petitions one after the other, the content, the very objective the Supreme Court ruling sought to prevent. You desecrated the bench that you were a member of. Again, you desecrated Article 1468 that demands that such proceedings be made in camera. So clearly, she went rogue, ready for all the consequences because she knew exactly what she was doing. So if this in its own does not constitute stated misbehavior, that is enough basis to remove a Chief Justice from office. What else would qualify as stated misbehavior? Senior counsel. A Chief Justice who ought to know better. And your justification was that the petitions are already in the media. Who leaked those petitions in the media in the first place? Because His Excellency President Mahama had cause in one of his correspondences to you to caution you not to leak documents because you have already leaked a letter meant for him to the media before it got to him. And truly, after he gave you the petitions, Assassin Radio, a radio station aligned to one of your lawyers because he's a leading member of the MPP, the former Attorney General, and the very person that they accused you of being in bed with at the time you were Chief Justice, who happens to be your defense attorney now. A leading radio station aligned to their party was the first to publish it on their website. The full contents of the petition and the full contents of her responses. Do we need an angel to descend from heavens and tell us who leaked those petitions to that radio station? That's one. So that is Madam Araba Torkornoo for you. And you proceed on the basis that these things are already out in the public domain to run commentary on it. Is that enough justification? Even after your colleagues on the bench cautioned against him and gave orders to that effect that it shouldn't be done. And our Constitution under Article 1468 prevents same from being done. So this is a woman who has declared war not just on the executive, but our constitution and her colleagues on the bench. It is clear. It should be clear to all of us. And Sammy, this cannot go lightly. Finally, because you are pushing me,
because I
can understand the discomfort. So, but
I discomfort in terms of
like in terms of your timing, not in the moment. So, but you see, finally, Sammy, another point that needs to be made has to do with the rather unfortunate judicial review application that Madam Araba Torkornoo has filed. I remember on another sister station and on this very desk, when I saw her supplementary affidavit, senior, to the Supreme Court, I concluded, I was clear in my mind that these were human rights issues. And so I was of the view that the appropriate forum ought to have been the High Court. And I remember advising that they should have taken advantage of the judicial review provisions in our constitution and go to the High Court. That was better clothed with authority to handle that matter. And I was convinced, apart from her call for an interpretation of the in-camera proceedings, I was convinced that it was a human rights, holistically her case was a human rights challenge dressed in the form of interpretation to clothe the Supreme Court with the authority to intervene. But today, we are told by her that she has filed an application at the High Court. But you know what she has done to herself? Senior, you would appreciate this better. The Supreme Court, in its ruling, in her first application, decided to strike out the content of the supplementary affidavit on the basis that it will constitute an affront. Going into it would constitute an affront to Article 146, Clause 8 of the Constitution, which demands that the processes must be in camera. It will be a breach of that provision. Today, you have taken those same similar concerns. After your initial mistake led to the Supreme Court in that decision shutting the door on the High Court to act. Because if your application at the High Court now rests squarely on human rights violations, of which the Supreme Court in an earlier ruling had indicated that it cannot go to. So if the Supreme Court cannot go into it because of potential breaches with Article 1468, you think that the High Court will violate the orders of the Supreme Court to entertain it under its jurisdiction on the basis of human rights? The door is closed. So I am waiting to see the kind of miracle his attorneys would perform. And no doubt, many of them are brilliant lawyers. But the only reasoning behind such missteps clearly is politics. So they are not being driven at this stage by the law because they have succeeded in convincing the woman and themselves that the whole process is political. So they are missing the thorny legal issues they could have taken advantage of. And in the process, they are shutting the legal doors upon themselves.
Okay.
So it has nothing to do with His Excellency President John Dramani Mahama. It has nothing to do with the National Democratic Congress as a party. It is Madam Araba Torkornoo's cross. And she must stand tall and face the committee after the committee is done with their work. And she feels strongly about the outcome of the recommendations of the committee. I think that would be the opportune time to take advantage of the power of judicial review given to the High Court.
Thank you very much. Hamza Suhini is a member of the NDC communications team. Franklin Kuja has joined us on Zoom. But before I go to Franklin, let me just hear the thoughts of Andrew Appiah-Dankwa, who is a spokesperson for the Movement for Change. So, what is the general, first of all, you listened to the press conference by the suspended Chief Justice. What's your general take on it?
So, Ellen, wish you a good morning. Wish my colleagues here a good morning. Wish your viewers a good morning. And to state unequivocally that, in my opinion, it's not the CJ that's on trial here. Indeed, this issue should not be handled in the interest of the nation as a simple NPP NDC issue. And that what is on trial here really is principle. Now, I think the lack of fidelity for principle the clear lack of respect for values is the biggest crisis we are faced with as a nation. And I think that issue is seen clearly in how this matter has been handled. That issue, or the lack of the respect for values and principle, is seen in the wording and the tone of the press conference. I think that it is important for me to state or to quote the thinking of Cicero in his book, The Republic, written in 54 to 51 BC, where he said that virtue and principles are the soul of the nation. So that if I'm saying that it's principle that is on trial, then in essence what I'm saying is the soul of the nation is on trial here. In 1992, the people of Ghana fashioned a constitution whose purpose was to protect, defend our lives, protect and defend our rights to our liberties, to protect our rights to pursue our own happiness, and an understanding that those rights are rights that God himself gave us, and the duty of the constitution was just to guarantee same. And so in that spirit, we aligned certain principles and values that reflected the principles and values of the people of Ghana, because we understand that a nation is not just about borders, but a nation really is about the soul. And the soul of a nation is in principles. So that where principles are being attacked and where clearly we are losing fidelity to principle, then the soul of the nation is being attacked. The CJ, in her statement, made two very broad statements that really caught my attention. One was to the effect that she was fighting not for herself, but for the people of Ghana. And then she quoted the famous words of Pastor Nimula, where he said they came for the socialists and I kept quiet. They came for the Jew and I. And these are ways and values that I think any right-thinking member of our society ought to align with. But clearly, contrary to what she said, as in the impression she gave, that suggests that this was a novel case. This wasn't the novel case. These issues that concerned how Article 146 had been applied has been had for a number of times. You understand? As in my brother Sweeney quoted rightly the 2013 issue with the head of Eshuaj. The same one, Article 146, was applied in the case of Charlotte Osei. And it has been applied in the case of various people. So that if indeed the CJ is fighting for the interest of the country, fighting for the interest of the country is to fight against Article 146 in its entirety, whether or not it aligns with the ultimate purpose, values of our nation, whether it aligns to a fundamental duty to defend an application of the principle of the rule of law in its entirety. If really that's what she's fighting for, like she was alluding to, then at least the least she could have done was, when this Article 146 was being applied in all its frailties, in 2017, 2018, the case of Charlotte Osei, all she would have done was to have written an article stating the issues with Article 146. Because in all fairness, personally, I have issues with Article 146. There are so many bits about Article 146 which are not consistent with the ideals and principles of our Constitution. Because if for 146, when you say stated misconduct, what do you mean? And you don't define it in terms of the process of Article 146, where there's no law that aligns Article 146. Yeah, you understand? It leaves room, in my opinion, for a lot of arbitrariness, which we know is one of the abominations of the rule of law. The rule of law states that the law must be predicted. You understand? How laws are interpreted must be predicted. You must not leave any chance for an arbitrary use of discretion. So that if your fidelity is to the principles of our Constitution and how those principles do not align with the spirit and the letter of Article 146, the least the CJ could have done was to have given an indication of her position. And so she's talking about they came for the socialists. We've gone past that stage. We've gone past the stage of they came for the socialists. We've gone past the stage of coming for the Jew.
When they came for them, you were
Yeah. Also, my brothers in the MPP, and I'm saying my brothers deliberately, because and I think I need to state this here again. The movement for change, for those of us who departed, who left that house, stated emphatically that we're leaving because we felt, and we still do, and I'm even more convinced now, that they've departed from those core values. We still stand by those values. And in the way they handle their power, and how they even handle opposition, even gives more credence to our belief that they've departed from those values. Because right now, the NPP as it stands has no value for principle. Because if they did, the arguments they were making here now, they ought to have made those arguments in 2017. When Charlotte this same Article 146 was being applied in all its frailties against Charlotte. You see, one thing that is clear is that the spirit of parochialness, what is in my personal interest, is what has fueled the NPP, and the same spirit that is what is fueling the CG. She is fighting for herself. It's not about us. She is not fighting for us. She is fighting for her personal interest. You understand? So people we put in leadership who are using the powers that are for us. First, if there's one principle that is clear in the Constitution, is the fact that sovereign power emanates from the people. And the people who are using those powers ought to use those powers in the ultimate interest of the people. But if there's one fundamental criticism I had about Nana Ado's leadership and the NPP when they were in power, was the parochial nature of the leadership they gave. That in almost every decision they took, their sole consideration was not in what is in the best interest of the country, but what is in the best interest of ourselves and our party. So that in the opposition to this process, their focus is not in fighting for the country. And I'm very disappointed that they want to find a way of putting this on the president when Nana Ado himself said that he's just a convener belt. Because see, when you analyze Article 146, you can see a deliberate posturing of that article to take any power from the president in how Article 146 was applied. Right. And that's why they deliberately use the word shall. And that's why they said that even where give it to a council of state, where the council of state gives a recommendation, you do not have an opinion, you do not have a discretion. All you need to do is just apply the terms of or the advice of the council of state, because the Constitution understanding that, listen, we cannot undermine the independence of the judiciary. Sure. Recognize that in how issues that borders on accountability, prohibiting accountability with respect to how the justices and some of the independent constitutional bodies act, then the president or whoever is the instrument through which those principles, those abiding principles of accountability ought to be handled under our Constitution, because justice should not only be done, but must manifestly be seen to be done to the ultimate benefit of the people of Ghana. Then the president should have almost no discretion in how Article 146 is handled. And that's why Nana Ado said that I'm just a convener belt in 2017, 2018. What did the NPP say about that statement? Because we know that because of the frailties of Article 146, it can be weaponized. And it was weaponized in 2018. It was weaponized. Because you see, so for me, I was thinking that we as a people, because principles, virtues, represent the soul of the nation, and because any act, anything we do, that seems to depart from our fidelity to principle, it really impacts the soul of the nation. Then as a people, putting on the heart of our Ghanaians as against our partisan colors, we ought to have a debate about Article 146. A massive debate about Article 146. You understand? It was essentially one of the issues I have with Article 146 is they are saying that what's called a decision ought to be made as to what's called whether or not a prima facie case has been made. And you know that underlying principle of our conduct is that you are using the sovereign power of the people for their purpose. So anything you do, because there is no monarchy, and it's a democracy, that anything people who are holding or using governmental powers that really belong to people, they need to have the backing of the people. But as the Article 146 stands now, and added to the opaque nature, the opacity of, it is so easy for anybody to make an insinuation that suggests that Article 146 is being weaponized. And that's what I'm saying, that it's principle that is on trial. But because of the nature in which the MPP handled themselves in the past, let me give them the benefit of the doubt. Let's say they are even opposing this legitimately. You understand? And with the interest of Ghana at heart. How many Ghanaians believe that? Because if really what fools you is principle, then why did you keep quiet in 2018? When it was being applied against Charles Osei?
You defended it.
If I don't, let me even go on the defend them. You understand? Because clearly, if there's something that I think is beyond contestation, is the fact that there are clear issues with Article 4.6 as it stands now. Because really, if you want to kill the danger of people making that insinuation that it is being weaponized, then it needs to be transparent. You understand? And so clearly, if there's one thing that is clear, after this, we need to have a serious reform in the terms of Article 146.
So they can have a clear definition of what misconduct is.
It should be clear. It shouldn't be left to any discretion. Because if you read Article 146 intently, also let me give you a background. In alignment to the abiding principles of probity and accountability, that's one of the principles that underpins our Constitution. You find that the Constitution has given clear provisions as to how the executive itself can be removed, how parliamentarians can be removed, and how the CJ can be removed. Now, what is interesting about how the wording of these articles that deals with accountability of the persons we give our powers to is that in the president, what it says is that the president shall be removed if in the parliament, it says what the parliament shall vacate their seats. When it came to the justices, it said they shall not be removed unless. So what it tells you is, and you see in the Constitution when they are drafting, every word, everything said there is done deliberately. So what it tells you that when it comes to removal of the CJ, it's not something that must be handled
just anyhow.
Just anyhow. And then goes that, but except for stated misconduct. Now, to align with the principle of the rule of law, I'm saying one of since the rule of law hits is arbitrariness and lack of predictability. So if really the people of Ghana we were interested in aligning to those principles, by now it should be clear what stated misconduct was, what constitutes stated misconduct. And I need to add that in what constitutes stated misconduct, Article 127 insulates the judiciary from the exit. So I agree with my brother here and the CJ herself on that proposition. But the Article 146, as in issues about it ought to be clear, so that what we needed to have done was to probably through a CI or something define all these things. Two, because the burden on us, and I'm saying this because they say justice emanates from you. So that the burden to dispense with justice emanates from us. And we'll be failing with that burden, because the burden is not just to dispense with justice. The burden is to give justice so clearly that it is manifestly seen to be done. So that immediately you have a clause that says that it must be held in camera. Then there's no way that moral bit of justice can be fulfilled. You understand? Yeah. I'm saying that the problem we are facing now, and that's what I'm saying, is principle that's being attacked here. That is the soul of the nation that is being attacked here. Is because the manner in which the CJ herself, people who had that privilege, and I'm not just talking about the CJ, all of us, myself included, because we've applied Article 146 in a manner that does not align to the principles of the rule of law. That does not align to the purpose for which we took upon ourselves the 1992 Constitution. But we've all sat down where they were applied in the past. We didn't question the lack of proprietiness or the lack of alignment of the terms of Article 146 to the abiding principles that underpin our Constitution. And so, if the CJ comes and she's telling me right now that this is not about me, I'm fighting for you, how am I going to believe it?
Okay.
Because even if she makes an argument like this, we have law review, University of Ghana, write an article and criticize or state your position about Article 146, how Article 146 does not align to our Constitution. You all take the MPP, they actually even defended an application of Article 146. They defended it when the president said, Nanado, said that I'm just a convenient belt. I'm not.
So in this case, President Mama is also a conveyor belt.
So on what moral grounds? On what moral grounds? Can you stand on the grounds of principle to make the argument that you are making? Rather, what we should do, if our interest really is to fight for Ghana, is to make a communication that suggests to the people of this country that this is not about our partisan colors, that we are fighting for the interests of the country. Yeah, understand. But merely reduce, and the media people also have reduced this to an MPP NDC battle, and forgetting that Ghana does not belong to neither the MPP nor the NDC. The sovereign power does not belong to neither the MPP nor the MPP. The sovereign power belongs to the people of this country. And under no circumstance should we continue to perpetuate this politics of putting the interests of our political parties ahead of the interests of Ghana.
Okay.
So for me, to conclude, I think that we need to call back and have a solemn reflection on how we've handled ourselves as Ghanaians, especially the people who are privileged to have had the opportunity of holding political power. That those of us who have had the privilege of communicating politically and how we do our things, we need to start communicating or giving the impression that in everything that we do, the interest of the country is prominent.
Okay.
And that's because virtue and principle are the soul of the nation. And in that, in the words of Jefferson, one of the founding fathers of America, where he re-echoed the thinking of Cicero, and it's by saying that strip a nation of its principles and values, and you are left not with a republic, but with a shadow. That these ideals must permeate into every sinew of our being, and that we all together build a nation that has a strong soul, and we will only be able to build that nation that has a strong spirit and strong soul.
Andy, thank you.
If we build a nation on the fair foundation of virtue and principle.
Andy, thank you very much. Andy appeared now quite spokesperson for Movement Watch. Richard, I've seen you writing a couple of. Hold on, I'll come to you. I'll come to you for you to, react. I've seen you. No, I'm not going for a break. I've seen you writing quite a number of things. Let me go on Zoom and speak to Franklin Kujo. He's been there for a while, listening to the submissions you guys have been making. Let me bring him into the conversation. Franklin, if you can hear me, thank you very much for your time.
Hi, Sammy.
Hi.
I'm enjoying the Sparrow and the deficit.
I know, right? Quoting the big ones in the way. So at this particular press conference, one thing that stood out for many Ghanaians is that the calls for her to resign in the mix of all these, ongoing issues. She said that no, she will stay on and fight. You think that's just enough?
Well, I mean, anybody who has her back or his back against the wall must be allowed to fight. You recall the SAL issue. We're fighting. We're still fighting. We still have SAL constituency, but we are fighting to make sure Amewu's nomination to Parliament was illegitimate. And so you need to keep on fighting, and there's no end to fighting, especially if you believe in your cause. So look, first of all, the Chief Justice must be given her due. I think that she's well within her rights to fight, but she must also be seen to be fighting fair. I think, for me, seriously speaking, the position. Well, I mean, the press conference was, if you ask me, very, very unnecessary. I mean, and then obviously I don't get into the content per se, but if I could just speak to one issue, I mean, all the other tangential issues about not being searched, family not being allowed. Well, this is not a day nursery. It's not a crash where you should be going to be cuddled and what have you. I mean, these are serious matters that we are discussing here, and I can understand that you need a family around, but those issues are tangential, really. I mean, the place giving her memories of people who have been murdered. Well, then you don't have to go to the cemetery anyway, because people are dead and buried all the time. In any case, look, I think the Chief Justice's position, what I take away clearly from it, while I sympathize with her, by the way, is that she's actually reflecting the sort of legacy she actually left the judiciary, which essentially means, well, why is she complaining about all these things there? Did she get to know? Did she just get to know that sometimes the way, let me be a bit funny, pedantic here. Justice Eniyeboah. I recall when we had this issue, the 2020 elections. I think it was 2020 elections when we wanted we filed an amicus. You remember? Together with basically saying that the Electoral Commission did not really need a new register. We recall that incident. The way Eniyeboah and a couple of judges spoke to us, for me, it was a shocker. And the way they were treating our lawyer, sit down. What do you know? Yeah, we are not even neutral. I was like, I asked some lawyer sitting by me. I said, is that what goes on here? So I have to go high court. The judge will come and carry you from your seat. I'm just trying to say that the sort of discipline, the sort of legacy, the sort of what we are dealing with. Everybody seems to have a story to tell about the judiciary in the country. I'm not saying everyone on the bench is problematic, but clearly speaking, day in and day out, people have been expressing the same sentiments. In fact, so she was actually echoing the very things that she was talking about. I mean, imagine we being told you are not neutral, sit down there. I mean, isn't it the same as being told probably being asked not to come? How do I even put it? I mean, the treatment is not similar. You understand? So people complain about the way cases are handled. You are not even allowed to speak. You are not. It's a whole culture that ought to change. And I think that if there's one good thing that came out of this, the Chief Justice's travels, I think it is one interesting education that she's helping us and taking the public along that, look, the judiciary I led was fraught with a lot of problems. And I'm seeing some of them even in my own case. I mean, that's the way I see her posture and the complaints she's making. Because look, didn't you experience Jakba and what's it called? That guy, what's the guy's name? Dami. Didn't you hear the things Dami did to that guy who was supposed to have won the elections? What's it? That Singh guy. Remember? The sort of treatment, the kind of language Dami uses in court, very disrespectful to senior lawyers and all of that. I mean, that was a culture they upheld. You understand? So why is she complaining? I'm not saying that she should be dealt the same way, but I don't think anybody has actually, for me, yeah, maybe she has issues around about the process and all of that. But I think, clearly speaking, she's just epitomizing exactly what every Ghanaian who had a stint on the bench must have been experiencing in one way or the other. So for me, that's the education we are getting out of it. And if we come out stronger, however her issues then, I think that we'll be better for it as a country. Otherwise, look, I struggle to understand some of the complaints, as I'm saying. The other point I need to make quickly is that again, it makes me feel, anytime I listen to the complaints and the way she thinks that maybe, and then she suggested that there's someone political, there's someone who's after her. And I ask myself, how do we even appoint our chief justices, right? I mean, look, the president just gets up and I don't know what they do, but whether they consult whoever they consult, eventually just hands over the person to us. And then some sort of, what's it called, interview in parliament, and then obviously she's appointed. I think we need to change that. And Kenya seems to have shown us the way. The Judicial Council or Judicial Service Commission in Kenya would announce a vacancy. People will apply. And when people apply, they are shortlisted, and the interview is live on TV. I mean, in Ghana, you have been watching Kenyan, Supreme Court, what's it called, interviews, and it's rigorous. You tell, and in fact, it's like a debate. You have all sort of people sitting there. It's being streamed live, and people are answering questions. You could tell exactly who will be Chief Justice, right? You don't even leave it to Parliament, so that you don't allow the the drama that occurs in Parliament. We need to change that and allow I think we should change. Hopefully, the Constitutional Review Commission, or committee will take this into consideration, because I think that it's also one of the thorny issues surrounding the way people perceive the Chief Justice to be politicized. And so, I mean, you can decide to basically disrespect everybody. So these are the other two things I've got to say. I think it is important that we learn a lot. We are learning a lot from what the Chief Justice is telling us, that look, this is your legacy. This is what you experienced. And this is what she experienced. And together we'll try to clean it up. Secondly, I think the process for appointing, Chief Justices must be changed. Thank you.
Franklin, thank you. Thank you very much. We'll come back to you for the next round of conversation. So, guys, I'll give each one a minute to wrap up on this. Rich, I've been seeing that you've been writing, God knows how many notes to react to.
But you know that 1 minute cannot do it.
So don't worry.
The matter to do with
Richard.
Your second issue.
Richard.
This is something that can be dispensed with in a minute.
Richard.
That the EC should go. It follows a certain thinking.
Richard.
So let's spend time on this.
So react to. I've seen you writing. If you want to react,
yes,
so
thank you.
go ahead and do your reaction.
Thank you. You see, Sammy, the NDC seems to be gloating about the processes underway to remove the Chief Justice. They're celebrating it. They're happy about it. You can sense from Hamza's, mannerisms, his tone and all. My brother almost fell victim of that. His recommendation that when that Article 146 processes were being carried on in the past, the Chief Justice should have written articles. I'm like, since when has this become a thing? Like, you should have written articles that you don't like it. Jesus Christ. You know how many articles people would have written that you, myself, hear anything that is happening around us you don't like, you write it because it will happen to you tomorrow so you can show your article that is why I wrote that article. That is something, really.
That's the only thing he said. He's also proposing that there should be a clear definition of misconduct.
I'm coming to that one. Sure. I'm coming to that one. You understand? But for that Article 1, that got me. I'm like, really? They are gloating. And I like Apiadankwa's beginning to say that the Chief Justice was on trial. It's principle. So I wanted him to proceed on that principle and tell Hamza that, what you guys are doing, citing what has happened in previous application, right? In the case of the Strike lady, in the case of Charlotte Osei, is not principle. That principle would be to defend the unchanging fact of life, which is that this thing, when you do it, because it's wrong today, it will be wrong tomorrow. So don't do it. And hold a middle ground where he can bring us all to rally on that. Then I can say that, yes, yesterday when this happened, I didn't defend it. I didn't believe in that. I had my reservations. But even that, the look and feel of it, that the matters were originating from the source, from the commission itself, necessitating a certain response, that these individuals can work together, and a process was triggered for their removal. Even that, I didn't believe in that. He should have held the middle ground, but he didn't. But you see, the point I want to make is that Hamza knows very well. I said it, but he decided not to hear it. That we are not alone. The New Patriotic Party is not alone in our opposition to this. This egregious conduct to undermine and subjugate the judiciary of our country, the New Patriotic Party is not alone. You know that. You are lawyers who belong to the Ghana Bar Association. Your own bar says the exercise that the president is engaged in is capricious, inconsistent. And you made a point, and I agree with you, that the stated misbehavior ought to be defined. And that's what the Ghana Bar Association said, that the actions are inconsistent with Article 296 and therefore unconstitutional. Hamza says, point to one thing that says the process is unconstitutional. There you have it. There you have it. That there is no clear definition. It's subject to your your interpretation what stated misbehavior is. And I have submitted to you that the matters that has been raised in the petitions largely contravenes Article 127(3), that a judge exercising her power has become a victim of dispensing justice. Justice Gertrude Torkornoo. And you have the evidence. And that's why, you see, her engaging the public. And I don't believe in those who are calling for camera and camera. I don't believe in that. Because we're building a democracy. Our democracy must see the facts and the matters that our Chief Justice is being subjected to, such that precedent will guide us to say that this thing in the Constitution that says that do it in camera is actually undemocratic, because it allows some people to hide behind the veil of that provision and abuse the human rights of our citizens. And no less a person than the Chief Justice. So yes, there are constitutional breaches to do with the decision to suspend the Chief Justice, the decision to subject her to this Article 146 process. The Commonwealth Lawyers Association, I will read copiously from their website their disagreement with the matter, so that Hamza will not repeat it anywhere. That, oh, the MPP alone, and Apia Down cannot repeat it alone, that the MPP, it's not the MPP. Your own Lawyers Association says no, that this is wrong. So not the MPP, but you have refused to be principled as you advocated. You have refused. I am saying that the NDC, as for the NDC, they are lost cause. Why? Because they are on a path of revenge. And Hamza has determined that, and the utterances of their communicators is clear that we want Justice Gertrude Torkornoo gone. And they will do whatever, including very, very flimsy excuses to achieve that. They'll do that. And I supported 201% to say that speak more on these matters. Speak more on these matters. Hamza made a point before I go to read this matter. He says that, oh, the door is closed to her, because Supreme Court has made a certain determination on the case that she's brought, and so therefore going to the High Court, she's not going to have any recourse there, because once the Supreme Court has determined, the High Court cannot go against the principle that has been established by Supreme Court. I'm saying that he has even wasted a time to give us details of the matter. The point is that whether Supreme Court determined anything, the door to any remedy was shut to her, because the idea was that she must be gone politically. A decision has been made. So what we are going through is just a charade. That's why they will not listen to the Ghana Bar Association. That's why they will not listen to the cautions being brought by the Commonwealth Lawyers Association. There's precedent, okay, in other jurisdictions that governs the conduct of removal of Chief Justice. If nothing at all, that should guide us. Franklin was talking minutes ago, he was talking about Kenya. So it's good to learn best practices from elsewhere. Matters to do with the removal of Chief Justice are not child's play. Consequential matters that bothers on our democracy. But this president has refused. And this lame excuses of yesterday it was done, is nothing to justify any behavior that we are seeing today. It is only a basis for people to gloat and to say somewhere, say, yes, we are also doing it. And the question I ask is that, who is the loser? Who is the loser? Ghana is the loser. Nobody wins in this matter. So yes, you can do it because you perceive that something was done yesterday, and now you think that, oh, you are causing a bigger harm. Look, Sammy, they are the lawyers here. Please, you are not moderating. Okay. Oh. I know that's what you're doing.
He's wrapping up. No, he's wrapping up. I'm timing him. I'm timing him, so don't worry. I'm timing him.
You understand?
I'm timing him.
See. So if in a situation, okay, and permit me, it's a bit violent. If I end up in a heated argument, I slap you, okay, and you slap me back, mine can be judged or be deemed involuntary reaction to the actions that were happening. But you perhaps will have thought about what I have done and intentionally slap me back. What the NDC is doing, they have perceived and calculated What may have been done yesterday
I give you
innocently.
opportunity, just calm down.
What may have been done yesterday innocently, perhaps not very thorough, or perhaps that can be excused. You have looked at that. Perhaps it's a mistake.
Okay.
Coming from whatever. But you now have looked at that mistake and you are coming back with a big bang, aiming at the foundation of our democracy. Now let me read for you.
No, I need to go.
No,
for
but I have to read for you.
I have to pay bills, Richard. I have to pay bills.
Okay, pay the bills and then I'll read. That's okay.
I need to pay bills.
But I have to read. And this is an independent voice we must listen. Thank you very much.
I have to go for it. We are still watching the big issue coming to you live from our studio here in Accra. It's also live on City 97.3 FM. We'll go for a quick break. When we come back, we'll continue the discussion. You're welcome back. You're still watching the big issue coming to you live from our studio here in Accra. It's also live on City 97.3 FM. My name is Sami. We are sitting for regular host Salam Adonu. Before we went to the break, we're talking about the removal process of the Chief Justice. The press conference she addressed this week, Wednesday to be precise, and some of the issues she raised in there. I was taking reactions from my panelists before we went on that break. So, Richard, I come to you in 1 minute.
Yes, I can read.
In 1 minute, so I can come to the other panel as well.
Okay, so I'm reading from the Commonwealth Lawyers website. It's commonwealthlawyers.com. It's a statement they issued, and I read. Statement of concern by the Commonwealth Lawyers Association on the suspension of the Chief Justice of Ghana. On 22nd April 2025, the President of Ghana, John Dramani Mahama, suspended the Chief Justice of Ghana, Gertrude AES Torkornoo. The Commonwealth Lawyers Association notes the statement of the Ghana Bar Association on 24th April 2025 and the Ghana Bar Association resolution published on 29th April 2025. The resolution states, the Ghana Bar Association calls for the immediate revocation of the suspension of the Chief Justice as it considers the suspension to be unconstitutional. The Constitution of the Republic of Ghana at Section 146 states, a justice of the Superior Court or a chairman of a regional tribunal shall not be removed from office except for stated misbehavior or incompetence or on grounds of inability to perform the functions of his office arising from infirmity of body or mind. The Commonwealth Lawyers Association notes the concerns expressed by the Ghana Bar Association and wishes to stress that the grounds on which judges may be removed from office and the process for removal should be clearly discernible from the legal framework under which they serve. And this is in reference to Article 296, right? Where a CI is required, which just it's not a page. Oh no, I'm not going to read the substance. I just state it here now. Okay, so it means you have read it, and then you are saying that we are alone.
Yes, so show me where
I am coming to that
they have
point.
condemned the action.
Just wait. Already they disagree.
No, not at all.
Show me the disagreement. Show me where they have disagreed.
So go to the go straight to the point. Look at the number of pages.
Why is it jittery? What is it jittery? But they are disagreeing on principle. He asked that
I want Richard on this platform to point out from that statement.
Yeah.
Where
Charles, you've read it. You have a copy. You've read it.
With me.
No problem.
And I'm going to make references to the statement.
Okay.
No problem. Okay.
In my response.
So I don't know why you are jittery. So
I'm telling you to show me where.
So here, the Commonwealth...
They say government is wrong. Show me where.
Wait. They say the Commonwealth Charter, and I have to read it so you can get a context. So
But he has a copy already, so he has he knows whatever is in there.
Reference to it, right? Mm-hmm. So when I read it, it doesn't need a reference. Just say what Richard said. Read from the side. That's okay. Okay. So the Commonwealth Charter states, we support an independent, impartial, honest and competent judiciary and recognize that an independent, effective, and competent legal system is integral to upholding the rule of law, engendering public confidence, and dispensing justice. The Commonwealth principle, on the accountability. You see, they lay a basis. So just, you're a lawyer. So just, you know,
Richard, that's why I asked you earlier. How many pages
it's
are
not
you
a
reading?
page. It's not a page. It's just this is very
It's
serious.
So
Lengthy statement.
just
I am not going to read all of it.
just read a conclusion. Just read
I read the conclusion.
I gave you a minute.
Okay,
I gave you a minute.
Okay,
You are going more than a
problem.
minute. And so I'll be forced to also give
You
them
know how many
extra
minutes I would
time.
have finished reading with this interjection.
He's trying to waste time.
He's concluding.
Okay,
So Richard, in
okay, let
30
me
seconds.
Okay.
30 seconds.
When we
Just
reference
30 seconds.
document, we go straight to the paragraph in question.
Oh, you are a lawyer. I have to lay foundation. They lay the foundation. They lay the foundation. So I'm just reading their foundation.
Richard, in 30 seconds.
Your viewers may not get the point. Anyway,
See,
but I go
buying
to
time.
it.
Sammy, you have to
I'm
make
buying time to do what?
Because he doesn't want us to
Richard,
Removal. Okay.
in 30 seconds.
No problem.
And I'll stick to that.
No problem. Removal or suspension from office is a very serious form of judicial accountability. Okay? So now let me just skip to it. It says the Commonwealth principle declares that judges should be subject to suspension or removal only. Yeah, just hold on. Only for reasons of incapacity or misbehavior that clearly renders them unfit to discharge the duties. The misbehavior and incompetence wording of Section 146 should be applied in this context. And now here's the context. It said the Privy Council of Rear Chief Justice of Gibraltar, okay, held that the removal of a judge can only be justified where the shortcomings of the judge are so serious as to destroy confidence in the judge's ability to properly perform the judicial
I give you 30
function.
seconds.
So now,
30 seconds. I give you 30 seconds.
I'm done reading. Now here's the point.
I give you 30 seconds.
No, wait.
I give you 30 seconds.
Let me just tighten it for you. No, don't do that. I'm just asking for a minute and you're arguing. The point is this.
Let me be fair to others too.
So
let them also have their final bite on this matter.
Allow. You are just taking the time by not allowing me. Here's the thing.
You can take all the time.
Okay. The point that is being made here goes to the heart of the GBA position, which the Commonwealth Lawyers Association agree with, to say that in the absence of an explicit definition of what a stated misbehavior is, okay, why they are not comfortable, because it is not clear what a stated misbehavior is. And here, the example in that case is saying that to consider removing a chief justice.
Okay, Richard,
the basis might be so much clear that nobody will argue against it.
I was supposed to give you 5 minutes to have a final.
But you have taken the time by trying to stop me. But the point is made.
You've spoken for 7 minutes. I'll give you 7 minutes as well.
No,
just to be fair.
For more than 7 minutes.
No, I mean, that's not fair.
I'm timing it. I'm
disrupted what I'm trying to present.
It's not 15. No, it's not 15 minutes. I am timing it. I am timing it.
Nobody's saying anything.
I am timing it. I'm timing it.
Let me make my point.
You haven't been fair. When I am saying you have stopped me,
I'm not being fair to you. How does this have not been fair?
Yeah, when you have given me the time, you should allow me to say what I'm saying.
You are done. Hamza, to be fair to you, 7 minutes.
See, when I was listening to Richard, I was laughing. I was full of smiles. Because
but you are gloating, of course, because you're enjoying the process. The chief justice is going through.
Don't let him
sympathize with him as well. In all honesty, I sympathize with him because I can understand the difficulty he finds himself in trying to defend.
I don't have one difficulty. I'm defending Ghana, not any political
party. Allow him to make his point.
It is ignorance of the highest order to say that stated misbehavior is not defined in the laws of Ghana. The Constitution is not the only law of Ghana. Our Chief Justice knows, as a matter of fact, that judgments from courts, especially the Supreme Court, the highest court of the land, constitute or form part of the laws of our country. And in the Charlotte Osei case, the Supreme Court defined stated misbehavior to include procurement breaches. So how can you, with this knowledge of the law, say with certainty that stated misbehavior is not defined in our law, in our laws? Where from that strange reason? When the Supreme Court has defined state and misbehavior for you to include procurement breaches, and in the allegations and in some of the petitions, there are issues of procurement. So who are you trying to deceive? That it is not defined. That's one. So don't repeat it anywhere, my brother.
Well, tell that to the Ghana Bar Association.
That is why I'm going
tell
there.
that to the Ghana Bar Association.
And I'm going there. Secondly, you claim that you have been supported in your stance by the Ghana Bar Association and then Commonwealth Lawyers Association. If you look at the Commonwealth Lawyers Association, it is proper that if you are taking a Chief Justice through such a novel process, every institution that plays a role in justice delivery must caution and remind you to do so in line with the remits of your law. That is not the same as condemnation. That's why you are struggling with their statement. I have read that entire statement, and it's proper. For them, like the Ghana Bar Association in their first statement, if you read that first statement, that was not hijacked by the likes of the former Deputy Attorney General, Asono Dapa, and their colleagues. And it was actually written from the offices of the Ghana Bar Association. You will tell that their caution was that they were monitoring all active players and that they should make sure that they act in line with the constitutional dictates of our country. It was nationalistic in character. It was a caution, just like the Commonwealth Lawyers Association. That is why my brother struggled through that statement to point out where they exercised or they indicated an opposition to what is going on.
But it's a repudiation.
They have, please, I was quiet. They have
don't say that.
They have cautioned that the processes must be done in such a way to reflect the true limits of the law. They have not pointed out where they consider a flaw as far as the application of the laws are concerned.
Oh, they did.
But you couldn't read that out?
That's what I read.
What you read out?
In the example of the Gibraltar case where they said that the stated misconduct must be explicit.
No.
They must not be subject to interpretation.
They have not told you that in this case, stated misbehavior is not explicit. Show me where they have said that.
But why are they bringing it if it's not relevant? They are telling you that they agree.
No, Richard, come on, let me land. I was not engaging you this way.
Or you were interrupting anyway.
No, I was not.
You were.
You see, they have told you that it is in line or must be in line.
Yes, because this one is not.
With the wording and the misbehavior or incompetence wording of Section 40 should be applied in this context.
Yes. And they
should be applied.
Basis.
Listen, please.
Okay.
They said the misbehavior and or incompetence wording of Section 146 should be applied in this context.
Right.
They are telling you that they don't have a difficulty in identifying misbehavior. They are just telling you that the misbehavior as captured under Article 146 should be applied appropriately, unless the English language is lost on you there.
No, it's not. But you see,
and they have proceeded to, as a tacit enforcement of that caution, to make references to a case that upheld that stated misbehavior. So it is even a guide to the committee that is sitting today. And the committee can reach into the arsenals of that case and use it as a persuasive weapon in establishing their stated misbehavior, if you don't know.
Okay.
Because it's not a decision of the Supreme Court. Please, let me.
Let him make his point. Let him make his point.
You see the point? So let us get that fact. Let us not confuse it. Let's not say it anywhere. Now to the Ghana Bar Association. After elements of your new patriotic party, led by the former Deputy Attorney General, went to hijack the process.
How did they hijack the process? No. This is the second time you are making.
My brother, even they were on their platforms calling on all lawyers sympathetic to the NPP to appear there quickly for them to force that vote. We all know. I was out of Accra, but I know.
So how does that amount
to hijack? No, I'm coming, but we know about.
How does that amount to hijacking?
So they went to overturn the decision.
All these allegations against your bar association.
They overturned the decision. And if you read their second statement, their issue was with the suspension.
Yeah.
It had nothing to do with the process. Their issue was with the suspension. They were challenging the president's power to suspend. and said that if it is not revoked, that false political narrative that was issued, that they will go to court. How many weeks has it been? How many months has it been? Is the GBA in court questioning that presidential directive in consultation with the Council of State? What has happened? If indeed the GBA was clearly committed to that statement and it represented the GBA's position, you think that by now the GBA wouldn't have been in court? Why is the GBA not in court? Challenging that suspension.
I can answer that question.
Why?
Because the doors are closed.
The doors are closed. There's no remedy anywhere. I mean, I beat my brother.
There is no room
So
anywhere.
they did not know that when they were making those decisions. So it tells you that you are on your own on this drive.
They are walking alone.
You are walking, but they are walking alone.
They are not Liverpool.
And that's why I'm telling you that I sympathize with you. Again, Sammy, another interesting point my brother made was the attempt to twist the facts and say that we rather are being unfair to the facts of history. Remember, when they were removing Charlotte Osei, there were thorny issues we made references to. Our problem was not with the presidential decision of the establishment of a prima facie case. Because remember, with Charlotte Osei, it was the Chief Justice who had to determine the prima facie case, not the president. But the difficulty we had was with the faceless manner of those petitions. The petition was not signed. The individuals behind those petitions could not be identified. Yet His Excellency the President, Nana Addo Dankwa Akufo-Addo, at the time, proceeded to act on say. And when we raised those issues, he quickly called them to come and make changes. Do you know the petitioners, apart from the lawyers who purported to have been representing him, and eventually was in fact appointed chairman of the government's committee of the 2024 election campaign of Dr. Mahmoud Bawumia? He was my evidence lecturer at the law school. Known as far as his political affiliations are concerned. Can you say, with the petitions calling for the removal of Justice Torkornoo, that these are NDC activists or players? Can you? With certainty, with your head up? I've just given you a clear example. In the case of Charlotte Osei, where their entire government machinery and the political party was involved.
How's that?
You are not the host, I beg you.
You asking your
thoughts.
who are Shining Star? Who is behind Shining Star? You asked the question, so I want to know.
don't know.
What? The Chief Justice doesn't know. They
I know
don't
that
exist.
Oliver Bako Vamo was the name.
Yeah.
I hope I'm getting the name.
Yeah.
Yes.
Is he behind Shining Star?
I think he's one of them. But the information the Chief Justice has let out.
Well, so,
But I can assure you that
nobody
you
knows
know,
them.
is
They are
Oliver
not
a member of the
registered
National
everywhere.
Democratic Congress?
I don't know.
Nobody knows.
Is he a member of the National Democratic
I don't
Congress?
know.
Nobody
So
knows.
why don't you know? If he was a member, wouldn't you have known?
You should tell us.
Wouldn't you have known, Sammy? You would have known. But he is not a member of the National Democratic Congress. Indeed, go to his Facebook wall today. There are instances he has taken even the new NDC government to the clinics.
That's strategic, Master.
What's strategic?
It's strategic complication. Don't be telling us those things.
In any case, it is not his
strategic
petition
complication.
that the Chief Justice is worried about. And even before their petition, we had seasoned lawyers in this country, the likes of Kweku Azar. They were amongst the first to file petitions calling for the removal of Madam Justice Torkornoo. We did not have such incidents under Charlotte Osei. So the partisan narrative surrounding Charlotte Osei was palpable. And if references were made to it, we're not questioning the applicability of Article 146. Remember, we're questioning the partisan nature with which it was handled. We never had any issue with Article 146 because President Mahama, as president, applied it when you people invited him to apply it in the case of Loretta Lamte, an appointee of the NDC government. He applied it and removed Mrs. Loretta Lamte out of office. It tells you that as a party, we never had issues with the applicability of Article 146. Because we are on record to have applied it even before you assumed office. So there is no double standards on the part of the NDC, and that is why my senior counsel couldn't have accused the NDC of being double standard in this matter, on this matter. That is the difference, Richard. So you see, you are dealing with a very meticulous political party that has a very tact leadership, that has a president who values our democratic ethos and understands, though not a lawyer, the relevance of our 1992 Constitution and the need to respect it to the letter. That is the difference. And that is why I started my submission this morning by saying that the NPP should thank God that President Mahama is the president of the Republic of the country of Ghana at this point in time. Yeah. Indeed, Madam Torkornoo herself must thank God that President John Dramani Mahama is the president now. That is why many of them can still hope that maybe at the end of the day, she might be found not to have done any wrong. And the committee has not said that she has done any wrong. The executive has not said that Madam has done any wrong. Absolutely not. The process will establish whether she has done a wrong or not. And you see, it is for good reason. I'm not discussing the merits of the petitions. I am not the subject. In terms of the legal profession, Madam Justice Araba Torkornoo is miles ahead of many of those who are seated here. She's miles ahead. So if as a young lawyer, I still value the ethics of the profession and I have refrained and resisted the invitation from the likes of Richard to respond to the contents of the petition, I am struggling to understand why the woman who ought to represent the moral fiber of the judiciary of this country would herself be dragged and allow herself to be dragged to commenting on something that is supposed to be in camera. I'm still struggling to understand it. In all honesty, it is not as if we do not have responses to the contents of the petitions being run. We do. But out of reverence for our profession and the ethics, that is why we are not going to the substantive issues. And so I expected her to do so, especially so when she benefits from the privileges that comes from that position. A higher responsibility is placed on her. She should be the last to engage in acts that undermine the sanctity of our Constitution and its provisions. And most, to a very reasonable extent, even to decisions of the Supreme Court, of which in the not too distant past, she was a member of. So I expect that reverence, that respect, that dignity. But what do you expect? If in government, one of the challenges or issues raised against her leadership as Chief Justice, allegations, had to do with perception that she was under the direction of the then Attorney General, Godfrey Dame. And that even in terms of setting out dates or giving out dates for hearings, it was largely influenced by Godfrey Dame. They denied it. And of all the lawyers in the country, suddenly out of power, it is Godfrey Dame that she deems appropriate to represent her.
He's a lawyer. He's a lawyer. Every client. Every client. Every client
don't do that.
Has that. Had that discretion.
Every client has that discretion.
I may want to have you to
but you understand. You know that my caution is not out of place.
But the way you put it,
you see,
it's not proper.
I gave the basis. You like giving basis. You took a question and then you
I was reading people's basis, not my basis.
So why are you telling me of basis? You see, I'm giving you basis of that relationship. No law bars her from making that choice. But you and I, placed with such responsibility, I would not have made that choice. I would never have made that choice. And so that's why I'm surprised that she more or less gave a tacit seal of approval to the perceptions that were being held about their relationship by actually proceeding to make that choice of a counsel. That is worrying. Okay. And so, Richard, unlike you people, we will allow the processes to take its course. But when it comes to my personal opinions as to whether he should go or not, she should go or not. Okay. I think that it doesn't matter.
Hamza, you're 7 minutes.
What matters is
you don't have to come 7. This 20 minutes is 7 minutes. I mean, you see how I was quiet? It was 7 minutes. I'm not talking about you. I'm not. We have 2 more issues. We have 2 more issues to discuss. So you see, I'll come to you. You see, you give somebody 18 and give me 7. 18. Yes, it's an 18 minutes. He give you 15 minutes. Appear for me. Go ahead.
You see, and this is in response to my brother's attempts at a rebuttal on the fact. On the issue of whether or not they are working alone or not.
Is he a Liverpool supporter?
No, I'm a Liverpool supporter. So I don't live working alone. I'm a Liverpool supporter.
Look at somebody who doesn't want to walk alone and proposing for others.
No, I'm definitely not working alone. But we are working alone.
But we are not.
So you are. One. On the issue of the Bar Association, I think I said it here. On this platform, on the issue about a month ago, that 1% of a group cannot attempt to make a decision for the entirety of the 100. Yeah. There's about 6 something people call a conference and attempt to make a resolution, which contradicted the true position of the Ghana Bar Association in an earlier statement. So I don't know. I don't see how that flawed position helps your cause, because I think we need to understand that position or that 1% lacked legitimacy. So that one, please don't go there. And 2, after listening to Richard, I think you are, and I think Hamza made the point. I think I have to re-echo that point, that the banner headline ought to be the MPP admit to taking a wrong position in the issue of the application of 146. That should be the banner headline. And it's becoming one too many. Because you're recalling the issue of the parliamentary issue when they attempted to apply Article 119. And then people came out, or when reference was made to how the former speaker handled it. Now, the former speaker was wrong. The fact that he was wrong does not mean that wrong should be perpetuated. The MPP has lost so much moral authority, moral right. Indeed, I think I must say, and I wrote something here, that a political party that defends a constitutional process when it sues its agenda, but denounces the same process when it is applied to its own, forfeits the moral right to speak of justice. Principle is not convenience. Principle is not convenience. It is consistency in the face of changing interests. That's the problem the NPP is facing right now. And so when they speak, nobody wants to go into the substance of the matter. The mere fact that they are speaking, people don't want to listen because they've lost so much moral authority. Because this same issue came up in 2018. And the position was, oh, it's right, let's deal with the 146 is okay. There's nothing wrong with Article 146. And suddenly, when I beg you, let me land. I beg you, let me land. No, but the point is making is materially incorrect. It is not. Nobody said that. Nobody made that argument. Show me one person who made that argument. Nobody said that. So in nobody said that. When this same, and even Hamza admits that. Please. What do I admit? You admitted that. What you say? In 2018, when the same process
nobody made that argument. I beg you.
Indeed, in during communication, they supported how it was being applied on Madame Charlotte Osei.
Yes.
And then they are happy. Yes. So the point is, what is the issue? What are they fighting for? And then I'm making reference to the Parliament, what's it called? Issue 2. So as a political party, we've lost the moral authority that moral right, that moral essence to speak on national issues, because their agenda clearly is one that is parochial as against nationalistic. Their focus, their purpose is to advance their parochial political agenda, not the national agenda. Two, he was questioning why they need to write articles. See, there's something we don't take seriously in this country.
You promised me 5 minutes.
Oh, I'll finish. No, he promised
No,
me.
he needs to know.
He promised me. I'm entitled to 80 minutes. Fine. After that, I won't go.
Why? Is he a team on this side or
No,
is he a team? There seems to be a team on this side.
A team of Ghanaians. We are all a team of Ghanaians. You understand? He was questioning the reason why, or undermining, or make, or I think undermining is too strong a word. Sorry, I'll withdraw that word. He seems to be questioning the essence in writing articles to state your position when issues that borders on national interest are happening. And I find that to be very surprising. Because see, if our focus, our aim as a people is to build a politics that is premised on principle, a politics that recognizes that virtue and principle constitutes the soul of the nation, and we want to build that strong nation that has a strong soul, that together can create that environment, that system, that will give all of us, anybody who's called a Ghanaian, the best opportunity of fulfilling their personal ambition. Then it behoves on all of us. There are people who hold certain positions where matters are happening, which clearly depart from the values you claim you believe in, or which do not align to the values of the state. You understand? But for whatever reason, you are not in the position to make a decision, to write and state your position. One, to attempt to prompt a departure from asset values, and two, to tell the whole world what your position on the said matter is. Because this same principle, that principle is not convenience, but it really concerns the face of changing interest, is the problem that the CJ is facing now. Because nobody is interested, people are not going to the merits or not of the issues she's raising. Now, I'm not saying whether she's right or not. Deliberately, I'm not going to her issues. But the fact is, majority of Ghanaians are not even interested in the issues. The fact is, in their view, in the position that you were in, you failed to state a clear position when these issues you are claiming today, you are fighting for, and quoting Pastor Nimola. Because of your tacit silence, in the face of your belief that Article 140 was being wrongly applied, or that 140 itself is deficient, it really shows that the socialists, the Jews, the gypsies, they've long gone, and that you've lost the opportunity to give a credible opinion about this issue to the detriment of not just herself, of the entire nation. And if there's one thing history will tell us, and I just want to give that just one example. In around 1812, you know this great American Alexander Hamilton, when America was building itself, and there was a debate as to the economic angle they should take, and he proposed an economic policy that was not protectionist. At that time, people rose up against it. They did not agree with him. Long after he was gone, America had to fall back on. He said to write an article on his position. They had to fall back on everything he said, and it's one of the reasons why America is so strong economically. You understand? And so don't undermine the power of stating your position by way of articles. We should run a country where if they mention your name, Andre Pedanko, people go after Andre Pedanko, this is his position, this. If you take this to Andre Pedanko, it won't work. If you take this to Hamza, it won't work. But we can't continue to build a country where our values, our positions on issues, national interests are fluid. You understand? So, I think I didn't use 5 minutes. And so, to end, well, I don't know Richard's position personally, that he was saying that he did not support how it was applied in the past. I don't have a cause to doubt his position. Have myself been in the NPP at that time, because at that time, personally, I didn't support that position. I did not do anything, you understand, against that position. That's why I said that it's not just the issue is not just about shelter. It's a collective failure of all of us, myself included. You understand? And so For me, I think this is an opportunity. I shall say, sorry, Madam Torkornoo. She has said the law is the law. Unfortunately, yeah, she said the law. The law is the law.
But that is not a truism.
No, I'm not going to give what's it called.
Is that a truism? It's subject to who is enforcing the law.
She herself said that the law is the law. Article 146, as it stands now,
You are not providing adjectives for her.
Are you a spokesperson?
She said that in context.
Article 146, she said that Article 146, in all its frailties, in all its deficiencies, is the law. And in my opinion, I don't think nothing has been done so far.
Okay.
Which suggests that
the
law is being departed from.
Okay.
Rather, if there's something that we should push and we should push for, is that we need to have a serious debate, discussion about Article 1.
This particular article,
and fashion together as a people. I'm not saying that my thoughts are
I don't disagree. I don't disagree.
But we need to have a deliberate discussion about Article 146 and find ways in which, in how it is interpreted and applied, the principles of the rule of law will not be.
I'm sure as the Constitution Review Committee, is working, I'm sure that issue will come up.
Pretty much.
And then they can do
is a living organism.
They can do. No, Richard, hold on. Let me do Franklin.
Not on the same issue.
But we are done. Gentlemen, no.
I am alone.
How is that? Richard, I have given you enough time. I've given you enough time to express yourself on this matter. Let me go on Zoom and speak to Franklin Kujo. Franklin, I want to have your final bite on this CJ issue.
Oh, well, I have nothing significant to add at all. I think I've enjoyed the conversation in the studio. I think we should learn from some of these things as they happen, and then tighten our laws as we go ahead. But I don't think in the words of my good friend Kokuda Huankra, judicial accountability should not be confused with judicial independence. And I think those words are eternally should be eternally etched in the etched on our minds. And I think that we should strive to be accountable anywhere we are. And so that's what I'll say for now. Thank you.
Franklin, just stay on. So I start the next topic with you. The national chairman of the NDC, in a recent interview said that there's going to be some leadership changes at the Electoral Commission. He believes that the chairperson of the commission and her two deputies have been more or less bad as far as the management of the electoral body is concerned, and he accuses them of incompetence. I know you've had issues with the Electoral Commission when it comes to SAL and the rest, but then such a comment coming from the national chairman of the NDC, and on the back of the processes to remove the Chief Justice, should it be a worry that such a comment is coming from the national chairman?
Well, if there's anything I need to give to the chairman of the NDC is that he really doesn't hide how he feels about the issues at all. I mean, he's spot on. He's upfront of it. He doesn't do any of these witches dance of moving 2 steps forward and moving 4 steps backward. And I think he's been saying these things way before they had their issues in court, right? Before they went to court and all of that. The 2020 elections, for instance, the way it was handled, the whole idea of having the registration centers, collating centers, I mean, without any serious administrative thoughts, actually signaled some of these challenges that we started having. Don't forget that the EC itself, I mean, just take myself out of the SAL issue. Let's even leave the SAL issue aside. I mean, administratively, I think they've had challenges. Challenges they imposed them. I mean, these challenges were self-imposed. I'm referring to the regional collation centers, which eventually led to the killing and maiming of about 7 or so Ghanaians, for which I still don't know the status of that case, by the way. And of course, the procurement issues. People rarely forget that the amount of money the EC spent in the 2020 elections. We estimate that we should have spent probably 1/3 of that money on the elections, and that there was no need for all these unnecessary registrations, what's called a new voters register. Recall that all these things we talked about, that they claim all the equipment we purchased were kaput when they had used them in 2019. All of a sudden, all of them were dead. We just found out recently that they had disposed some of them quietly without going through the normal processes. So, out of the litany of sins that the EC has committed, I think if we were to chart a path from here to heaven, we'll probably go thrice over and then come back again back to earth. But I've just got to say that, and what annoys some of us is that just the evasiveness with which they do their work. Nobody is saying that once you are clothed with some constitutional power, you don't need to answer to anybody. And I think that thing must be watched. Even Charlotte was said at the time, well, she's a good friend, but I've got to say it, and she knows that. I mean, the way she engaged the public at the time was a bit quite nauseating. This is our logo, we like it. Those things, when you keep doing those things, you're actually telling people that, well, you are even Afarijan. You recall when the NPP complained, they said you can go to court. You remember, but when they went to court, you started seeing the unraveling of some of the when he was in the dock. It's not easy to say such things, and I feel with time, people who have been clothed with constitutional power, sometimes by the way they conduct themselves publicly, can be quite annoying and nauseating. The EC, the current EC, took it to the highest level, but then they were not just incompetent. I mean, if somebody is so incompetent and at the same time pretending to be wise, it's double jeopardy, really. I mean, it's annoying, and then the person is evasive and all of that. It's triply. There's a word like that, triple annoyance. So for me, as I said, look, I was making the point that their high-handedness in ensuring that we spent money we didn't have. Don't forget, at the time, they were not even interested in listening to the donors who wanted to contribute to election because they didn't want to be controlled. You recall? And so they said, "Oh, Ghana can do it." They spent so many millions of dollars, which was part of the reasons why we went down so fast when COVID after COVID struck. You understand? So all these monies that were spent could have been saved and utilized properly. All those equipment they bought, which were not necessary, because the equipment were too pricey. Even Zimbabwe, can you imagine countries like Zimbabwe, which you wouldn't say democracy was particularly pristine idea there, were purchasing the equipment, the same equipment from the same manufacturer at almost $600 to $800 less per one. We saw all of that. All these records are in Parliament. But when we were doing that, people thought we were just not interested. We didn't like the EC. We went all the way to the Santini to make a petition because we felt that, look, these matters were important. We're trying to safeguard the interest of the Ghanaian, saving money. And one of the things that annoys me in this country is that when somebody seems to be performing a role because it's constitutional and the person is even making silly mistakes, they say, "Oh, hey, allow them. They are the only one who knows how to do this stuff." And because of the hide under the cloak of, elections are so sacrosanct. If we make a mistake, say Thomas say, the machine, if you don't buy it now, we don't do it quickly, and you buy something faulty, it will affect the elections. You see, so we sacrifice what I call diligence and a bit more common sense on the altar what's the word I want to speed, because they are constitutionally clothed. And Apia Dankwa makes a very important case. I think it's about time that people are known for the positions they hold. You write some of these things, but in the Ghana, it's fuzzy. So you don't know. People say, "Oh, we're NDC for." That's what they were calling it. Today is MPP, we are MPP. Today we are and then they just destroy the debate. When you look at the trajectory of this EC itself, and again, being very totally unbiased. I hope you accept the word, Richard. You accept the word unbiased. I have always been unbiased against the EC. You know that. It's part of the SAR treatment. But I'm just saying that as a Ghanaian who has vested interest in the way we financially manage our affairs, I felt those decisions were so wrong, and they deceived everybody. And because we said, "Oh, we needed to go to elections quickly, let's go," they quickly went to Parliament, got everything done and purchased. They said they never procured any, all the equipment were dead. But 2018, they purchased about 2,500 of these machines. 2016, they purchased other ones as well. In fact, 2019, they purchased equipment. How could those equipment all die in 2020 all of a sudden? But that's what we're told. So And you remember when they did the procurement, we all saw it through. If you didn't follow the procurement processes carefully, you would never have seen how they rigged the tender. They rigged the tender in terms of calculating of figures. You recall that the chairman of the tender at one point said he wasn't going to sign that tender, and he resigned because the way the tender was put together was rushed. In fact, the people on the tender, it was only one person who was qualified. We wrote all of these things there. You know, so for me, I'm not surprised that except that there's a political figurehead who is not saying that they are incompetent. And I think we should drill down, separate all the partisan noise, propaganda from the real issues, and look at it carefully. And I seriously think that there must be a lot of inquisition regarding financial projects in that regard. For me, this matters for me. I mean, everybody knows my position on this. Not to talk about the high-handedness of SAL. As of that one, if I add that, I mean, there are things they to be as read as I don't know what to describe it. So that's my position. I will not cry for them, but I hope that it's done properly and there are no faceless petitioners. I will never petition because everybody knows my position. We petitioned the Shraj already on this matter, and I think they are working on it to see what they can do concerning some, not necessarily their removal, but to just prove that they were high-handed, they were evasive, and they were somehow complicit in our financial woes.
Okay, Franklin, thank you. Thank you very much for your time. I come back in studio. Apiadanko, I'll come to you. I'll come to Hamza and Reggie later. But
Richard wants time to talk.
I'll give you opportunity. Okay. I'm a very fair person, so I'll give you opportunity.
Not today.
to see. Apiadanko, there are those who have said that the NDC as a party or in government has an agenda to remove certain heads of certain state institutions because the EC, the CJ is ongoing, and now this coming from a national party, national chairman of the governing party also coming in. There should be cause for worry that there's an agenda to take away the heads of some state institutions. Are those comments justified? As in the expression people have, you know.
Well, that's the perception out there, and I think it's a perception that the NDC as a political party ought to take seriously because as long as that perception persists, then there's a potential of undermining a genuine attempt in line with the reset agenda to correct some of the ills that was done over the past 8 years. Because I agree with Franklin Kujo, and I've agreed always with his position on SAL. Because that was a sin, not on the people of SAL alone. It was a sin against our constitution. And the sin that I think, in all humility, and in line with the principles of probity and accountability that underpins our constitution, that sin needs to be corrected. And if it means somebody petitioning for the removal of the chairman of the EC, I think that position will be a legitimate one. And so far as it goes, is in line with the laws of this country. Also, some of us during the 2024 election stated that one of the reasons for which we needed change was so that there will be a restoration of the lack of political credibility in our country. And one of the reasons why our political leadership lacked credibility was as a result of the irresponsible decision of our president, the president of Ghana, to appoint onto the AC people who were perceived, and I'm using the word perceived here deliberately, who were perceived to be members of the MPP, and I think that burden isn't just about the MPP, but who are perceived to have a political coloring onto the EC. Because for all intents and purposes, somebody like myself should never be appointed onto the EC, because I have a political coloring. Same for my brother here and Richard. As in, obviously because the duty of the EC, or let me say, because the duty of the EC is not just to deliver elections that are free and fair. The duty is to deliver elections which are perceived also to be free and fair.
Acceptable by all.
Yes. Then you'll be undermining that, or you'll be making it practically impossible for people to accept elections, when the people who are perceived to have political coloring are appointed onto the EC. And I think in line with our collective agenda as the people of Ghana to restore credibility in our political space, that wrong needs to be corrected also. But having said that, I think immediately that process also takes on political coloring, then it sort of undermines the agenda or the national interest. So as much as I believe that Isidin Ketia, as a Ghanaian, has a right to express his views on some of these things, because of the privileged position he holds as the chairman of the NDC, the party that has sponsored the government, then he ought to have restrained himself from that statement. Because essentially what he's doing is that he's already undermining any attempt by anybody to correct the ills I'm alluding to. Because we don't want a situation where a legitimate petition has been put in place. There'll be so much noise about it being politically motivated, or that perception that it's part of the agenda of the NDC to change some what's called institutional heads. Because the truth of the matter is, in line with the principle of probity and accountability, where any Ghanaian has been placed in any position, and they are handling that position in a manner that undermines our collective agenda as a people, or by reason of how they were appointed, that alone in itself takes a lot away from their credibility. It is our responsibility to start processes that will correct that wrong. Immediately, that process takes on a political coloring, and if you understand the culture in this country, then you'll be undermining that process, which is in our interest. And because of those reasons why I wished Isidin Ketia should not have made those comments. Yeah, really, he shouldn't have made those comments. And as I'm saying that, I want to state clearly that he has a right as a Ghanaian, but because of his position, he takes a lot away from any because there are legitimate reasons why the CJ a petition should be called to remove the EC. Now, how will the people of Ghana take it? They will go and read things. So instead of we going to the substance of the issues, and I think Frank Luge has made so many which I stand on all fours with. But because of that perception, people not even go into the substance of it and may dismiss it merely because they think that it is an agenda of a political party. Yeah, so personally, that's my view. And I think that we should not, the NDC as a political party should not play with that perception. Because that perception can hold grounds when such statements are made. So that in spite of the legitimate claims that the chairman secretary, and to refer to him, he's been very consistent with this position. Because it was a position he held when he was in the position, the position he still holds. But I would have wished that he would have restrained himself, because in spite of the fact that when you win political power, because executive power is given to the president and not the party, really, he's not in government. Technically, he's not in government. But unfortunately, because of the perception we hold, that is the party that is in power. You understand? People can spin a narrative. Okay. You understand? That can fight against what really is in the interest of the country because of the ills that has been committed by people who hold those positions. Okay. And I think that in how we do our things, we should always behave or communicate or advance arguments in a manner that always puts the interest of the nation ahead of your personal interest. Or that kills the perception that you are taking a certain decision because of your personal interest, whereas that position may be a position that's in my that's national interest, and that's my
Andy,
issue.
thank you very much. Andy Apia Dankwa, spokesperson for Movement or Change. I'll go for a quick break, but before that, let me read some of your messages that you've sent to us. Felix Ajiman from Kaswa says, "Good morning, Sami, and good morning to your viewers. Please ask Richard to quote one single provision in the Constitution that has been breached in the process seeking to remove the Chief Justice of the Republic." Ben from Sapama said, if Richard is saying that the whole process is flawed, he should tell us where the flaw is coming from. Joe Baba from Bogatanga says, "Greetings to you and your producers. I'm surprised to hear legal people or legal brains and not only condemning the CJ for what is going on, but also supporting the process, which is supposed to be in camera. One day, this thing will come back to bite us. Sammy, I'm happy that none of the NDC people are condemning this act by their leader. When the tables turn, we will all be here to listen to what they will say from Kisi in Ofoyu Krom in Kumasi. Master Planner Junior Kintampo says, great submission by my boss, Richard Ahiagba. Justice Torkornoo is not being treated fairly. Her statement on Wednesday was the best. And then the final one says, is Apia Dankwa saying that Jane Mensah is a member of the MPP and holds an MPP card? It clearly shows that he's, I'm not sure I heard him say that. Final one says, Sami, ask Hamza, if the tables should turn one day, I hope he will be here in the studio to also come and admit to whatever it is. You're still watching Big Issue, coming to you live from our studio here in Accra. It's also live on City 97.3 FM. My name is Sami. We have to go for a quick break. When we come back, we'll continue with this conversation and also discuss the MPP. You're welcome back. You're still watching The Big Issue live from our studio here in Accra. We're also live on City 97.3 FM. My guest today, Richard Ahiagba, Director of Communications for the MPP, Hamza Suhin, a member of the NDC Communications, and Franklin Kujo, President of Imani Africa, and Andy Apia Dankwa, spokesperson for the Movement of Change. Currently, we are discussing the statement made by the National Chairman of the NDC in respect of the need to have a leadership change at the Electoral Commission. Richard, Hamza, I'll come to you. Is your government or your party on course to remove heads of state institutions?
Absolutely not. I mean, that is the beauty of the National Democratic Congress. I'm sure that many of us listening to Apia Dankwa today, we would begin to have an indoors conversation in terms of how we handle some of these issues. But like they all agreed, like they all stated, he and that of Franklin Kujo, to the effect that when it comes to the interview granted by the chairman of the National Democratic Congress, this is not the first time he's made his position known on the matter. Indeed, that was even before the 2020 general elections. He's always been consistent, and not just Chairman Asaid Nketia, to a very large extent, many of us from day one, because of the conduct of the woman. And it was not the NDC alone. Even civil society organizations like Imani Ghana had cause to call for her head. And it was the first time in a brazen manner that the then president, Nana Addo Dankwa Akufo-Addo, decided to go as low as appointing TESCON patrons to the Electoral Commission as deputy directors of our Electoral Commission. So the partisan nature of EC started only when the New Patriotic Party assumed the reins of governance in 2017, January. We all know that as a matter of fact. And for us, irrespective of what the MPP says, as a political party, we pride ourselves when it comes to this democracy that we're enjoying. Sami? And for you to appreciate how committed we are to this democracy and the institutions under it, you need to even go back to the NDC's anthem, where we just did not agree to democratic governance and led the processes that led to the eventual promulgation of the 1992 Constitution. We also proceeded to anchor its stability in our national anthem as a party, where we said that from victory unto victory, the NDC shall lead a stable democracy. To continue to remind ourselves about the onerous responsibility of defending this fourth Republican Constitution and our democratic journey. So that responsibility is on us and is never lost on us. That is why many of us thought that there was a general call on us to at least bring some level of sanity to the Electoral Commission of our Republic after Nana Addo decided to desecrate it with the appointment of rabid NPP apparatchiks. Every Ghanaian agrees. Indeed, before the retirement of Afare Jan, that was an NDC appointee. But as political parties, I'm sure, and as citizens of the Republic of Ghana, we all respected the kind of leadership that he provided to the commission. And that made it clearly non-partisan. Handed over power from the NDC to the NPP and vice versa. That was the NDC's dream of a workable electoral commission. Unfortunately, the NPP, through Nana Addo Dankwa Akufo-Addo, decided to roll back the clock and injected partisanship into the operations of the Electoral Commission. So it is only proper that as a political party that has placed that responsibility of defending the democracy that we are enjoying on its shoulders and proceeded to even factor it into our national anthem, it is only proper that we reset the Electoral Commission to reflect the true mandate of the people as enshrined in the 1992 Constitution. And when we do so, it is not because we are embarking on a partisan journey. Because many of the promises we made to the good people of this country included a commitment to ensure that our institutions work in the interest of the Republic, not in the interest of any political party. And today, you agree with us that there are NPP elements, known active members of the NPP, holding sensitive positions in our Electoral Commission. It does not augur well for anybody, including the NPP itself as a political party. Because they would want to win elections and the legitimacy of the elections accepted by the Ghanaian people. But if you have your own partisan operatives in there, even if you win an election genuinely, there is a tendency for people to question the legitimacy of that exercise. So it is in their interest for them to come on board for us to ensure accountability and rebuild the Electoral Commission in a way that truly reflects the mandate of the Ghanaian people and their objectives. And I think it is important for us to appreciate that. It is not the NDC alone that raised these concerns. Like I indicated, Imani was instrumental in that regard. And maybe on a lighter note, when I heard that Franklin recently even petitioned Commission for Human Rights and Administrative Justice calling for her removal of the Electoral Commission, I was partially disappointed. Disappointed not in the action, but if there are people who are qualified to do service to this country in that role, he would have been one possible candidate in that regard. Because he's been a crusader of our democratic ethos since he came out with Imani. And he has done so well. There are times as a political party we disagree with his views. And I'm sure the NPP, they've also had cause to disagree with him. But they have remained true to their beliefs and what they believe should be in the interest of this republic. And so he could have been a viable candidate for that position. Like when we were looking for a viable one and we found Afare Jan. He could have. So that was my only disappointment in that petition. Because now, if people begin to push for the likes of him to occupy, then it creates the impression that that was why he filed the petition. His mind probably wouldn't have gone there because he is just doing national service to the Republic. So he's not interested in occupying any position. But at least there are times that your state can call on you to serve. And these are some of the fine brains we have in the country. So, but as for Asedu's chairman's call, you see, Api Adankwa, I can understand your caution, and I respect that caution. But the NDC is not a bunch of pretenders. And we want Ghanaians to be able to measure us by whatever we say. That is why chairman has remained that consistent. The assurance I can give, however, is that he has no say or whatsoever when it comes to the decision to hold the electoral commissioners to accountability. His power doesn't go beyond that of an ordinary citizen of the Republic.
He can influence.
He can't.
He can influence
because
the
this is no. That's what I'm telling you. He has no say. Knowing the president we are dealing with. You see, sometimes I think that people forget that we have in charge of the Republic of Ghana President John Dramani Mahama, who has shown at every level his willingness to privilege national interests over and beyond partisan interests. Remember that even during his first term, one of the challenges he had was his unwillingness to sacrifice our national interests on the altar of partisan politics. And in the opposition, that was one of his major challenges. Because we accused him and President Mills of being father for all, remember? Because they stood true. They did not allow themselves to be influenced. And today it is the same President Mahama. So the party can have its position, and we can be forgiven as a political party to have our position. But I can assure you, knowing President John Dramani Mahama, if petitions are brought to him and it doesn't make sense, calling for the removal of the electoral commissioners, and it doesn't make sense, President John Dramani Mahama will not entertain such petitions. I can assure you that.
Okay.
Even if it means being at loggerheads with the National Democratic Congress, I know that every step of the way, he will choose the national interest over the NDC's partisan request. And on this call, and I will state so forcefully, I find it very difficult to disagree with Asidun Ketia. From where I sit, I also feel strongly that there is the need for the Electoral Commissioner and her deputies to be held to account. And I do not think that they have demonstrated acceptable impartiality as far as their conduct in the last 2 elections are concerned. Because this is the first time we have had to go 4 good years without a section of our republic being represented in parliament as a result of their incompetence, gross incompetence. And that's what Apia Dankwa made reference to senior. How do you justify this? You conduct an election as electoral commissioners, and a section of your people, so the sole case.
Yeah.
For 4 years, they don't have representation, and the electoral commissioner seemed not to be interested in what was happening there. And we want to allow such electoral commissioners to still be at post?
Okay.
Absolutely not possible. So I would join anybody, including the likes of Franklin Kujo, who are calling for the removal from office of the current electoral commissioners because of that gross incompetence.
Okay.
I don't think that it is out of place for anybody to call for their removal from office.
All right.
And many of us will not be made, or will not allow the likes of the MPP to make it difficult for us to express our views on this matter.
All right.
The truth is that there is the need for us to clean that electoral commission and reset it. And if it means that those who are incompetent and partisan,
they should go.
Must go. So be it, if that is a demand of the Ghanaian people.
Okay, thank you very much. Richard, the final bite on this. Remember, you have the issue.
I was watching your time, so that's
Richard, we have 15
so don't interrupt me.
15 minutes to
See,
go.
now when you're coming to me, you're telling me what time was left.
See,
you didn't tell Hamza what time was left. I beg you.
Just let me finish. 60 minutes.
I beg you.
We have 15 minutes to go. I
was counting.
So I'll give you 10 minutes. You 10 minutes.
Look at that.
10 minutes is now. 10 minutes is now.
No problem.
Go ahead with your submission.
Sammy. You know, Apia Dankwa, you are not a social commentator. You are a spokesperson for political party. So going forward now, state your political party's position. This thing, that team thing is becoming glaring. State your political party position. You are not a social commentator. I like your analysis, fantastic. But state your party's position.
Are you confused about my position?
I'm saying that, is that your party's position?
No, are you confused
because
about
we
my position?
want to be able to hold your party to account to some of these things. So you are not independent making social commentary. Because you are almost speaking in tandem with the NDC. I don't have a problem. If that is your party's position, state it so we know.
Are you confused? No, I'll say my position. Are you confused?
Is that your party's position?
I'll say my position. Are you confused?
That's your party's position.
Yes. Are you confused?
Very good. Okay, no problem. So your party and NDC are one.
No party.
No problem. No, but that's a conclusion that is all from what you said. But that's okay. But that's a conclusion. That's part of my conclusion and they're interrupting.
I'll say my position.
So now I'm also my position is that your position and the NDC are one.
Allow Richard, go ahead.
Look,
and I beg no interruption.
Accountability is key. I am not opposed to holding people accountable if they have misconducted themselves, if they have done anything contrary to law, and that they must be held accountable. And so matters to do with the EC, if there are challenges there, let's apply the law. Where they have contravened, lay down administrative processes in law that establishes them, that they must adhere to in doing their job. If they go against it, they must be held accountable. Plain and simple. But I'll come to Chairman Astedo Nketia. But let me talk briefly about Hamza and his very grand effort to position President Mahama as a nationalist, one who is not partisan, one who says that is Ghana and is Ghana. But he came just yesterday, he sacked people who were appointed into positions, who had jobs, their livelihood, he took it from them. How patriotic is that? How nationalistic is that? How nationalistic is that? That's simply because he wants opportunity for NDC foot soldiers. He removed people from oppositions because he wants to put NDC people there. How nationalistic is that? Yesterday, he was in opposition. He was saying, oh, state of emergency is inevitable, must be declared by President Akufo-Addo. Today, his own friends are asking, please, state of emergency, because our forests, our rivers are devastated. President Mahama, the nationalist, refused to listen.
You see the danger and allow him to speak last. You see the propaganda angle he's
Hamza, let him make his submission.
But you see, look at Hamza saying somebody speaking last. Was he not the person who spoke after me?
Go ahead and make his submission.
He knows he will not get opportunity.
It is him talking, not me.
Hamza, you made your point.
No, but let him step. Otherwise, I will be compelled to respond.
Let's just be fair to him. Let him make his point. Richard, go ahead.
But you must have time to respond.
No, I'll put I'll put off their mics. Don't worry, talk.
Very well, thank you. So you see, the President Mahama, the nationalist, suddenly he will listen to the national call. Not to be a partisan president. Okay? So Hamza is telling us the partisan president is trying to paint him. The only reason you will do this effort by Hamza is because everybody knows he is not a nationalist as you want. He's a partisan. Look, this process that we have finished discussing about the Chief Justice, it is a partisan position taken by a partisan president, John Dramani Mahama. This is not a nationalist position. It's not. At all. It cannot be. That's it. So, President Mahama is acting in the interest of his government, which happens to be the NDC government, and they have an agenda. They are prosecuting it. We didn't have that. Just so to give you one example, since he is now in the business of glorifying President Mahama, let me just give him some small about Akufo-Addo. At a point when even we, the people thought, Ghanaians, were saying that the NDC was corrupt, okay? In 2016, we heard about all the corruptions and matters arising. Apia Danko is well aware of those. And when we came into government, people were calling for Akufo-Addo to prosecute those people. In a press conference, I'm sure you were there, you were at the Jubilee House. Akufo-Addo was arguing against positions that were carried or held by people internal saying that due process takes time, and that when you are not at the receiving end of it, you want it to be expeditious. But when you are at the receiving end of it, you would want all the privileges to be accorded to you. Contrary to position people held that prosecute them because they have been corrupt. We're talking about one who is taking a national position to grant people their constitutional right of due process of the law. Okay, so President Mahama is not what he's trying to make him to be. He's not a nationalist, a partisan president, in my view. With these actions that I've listed for you, you don't have time, otherwise I can list more for you. Now to Chairman Asedu Nketia. Okay?
10 minutes is up.
He is somebody I admire. He brings some light moment to politics. It's enjoyable. He's practical. He speaks with a certain wisdom, okay, that you appreciate, even though you disagree with his politics, as in this case, but you like him, okay? You like him. But what he has said, and this is not at him, but at what he has said, is utterly reckless. Reckless. And I'm not surprised. These things will materialize. The first stop is Chief Justice. She's a goner. The commentary of the NDC is clear and explicit that the Chief Justice is going to go, even though the evidence are light, they are not consequential, they don't meet the high standard set for them to follow. She's going to go. And immediately she's gone, they'll go back to remove the EC chairpersons. You can mark it. But where I would come here and say, maybe President Mahama is looking to become a nationalistic person would be when he says, no, I won't remove Charlotte Osei and co. But otherwise, this is cast in stone.
You mean Jane Mensah?
Finished, yes.
You said
Because you guys removed Charlotte.
No problem. No. Thank
You removed- didn't you remove
I'll, no problem. Just
Didn't you remove Charlotte?
So she will come back and remove Madame Jane Mensah. That's part of the agenda. It's cast in stone. Just yesterday and the day before, leading members of their party on platform, public platform, admitted, oh yeah, that one, she must go. My very good friend at the Jubilee House, he says, oh, she's a goner. She would go. The G-Mensa and Chief, they must go. Okay? So what Chairman Asedu Nketia is saying, incidentally, the chairman of the National Democratic Congress is just giving us a revelation of the agenda set for them to unfold. And we must be worried about it. So, I mean, it's not as if we didn't have issues with, what's his name, Dr. Afarijan. It's not as if we didn't. We had. We had plenty of issues with him. We had plenty of issues.
We also did at a point.
Okay, so are we going to continue? The charges that Chairman Asedu Nketia is hurling at the EC, are those matters that we're going to consider? Remove her? I don't understand. It's a style. My brother Franklin, I thought at a point, he wanted to be MP and all of that kind of thing. But the position held that Sal was a commission of EC intentionally denying people representation. For me, I cannot reconcile that. Yes, people were not represented. But how intentional was the role of the EC in that? How intentional was the role of EC? The matters were to do with law as well. What's the act? Act 936 or so. So if the people of SAL were to vote, having been carved out from Jessica, if they were to vote in that matter, who would our Minister for, Minister of Sports, Kofi Adams, who would he have been representing? And he would have been an MP for 2 districts at the time. And would not have comported with law. So what is the EC's error. Where is it? He mentioned also here was the West of God. We understand the matters were serious, things that happened, people were affected and all that.
Who did the demarcation? For
Okay.
the soul to help.
But the point is that, how is a security matter the direct competence or the lack of it of the EC? I don't get it. How is that? Chama say don't get it. Tell us. How is it the EC incompetent because security degenerated? And the NDC on the back of that say they pulled out of the election. How is that EC being able to stop it? They talk about, what's the name of the place? Ablekumanov. Now, the matter that is at issue is not the doing of the EC. It's the doing of the NDC. They were marauding over the place. On the day of election, when they won, everything spiraled out of control. The NDC was not controllable at the time. They were just running riot all over the place. They ran a riot. They beat our people. Took their pink sheets. Oh, I beg.
It's tough. We are done.
You understand?
No response.
No.
Are you kidding?
So
No
the point of it is
that's not fair.
I gave you enough time to make your submission. I gave Apia Danko also enough time. I gave Franklin enough time.
So the truth is that we need to tread cautiously.
Okay, you have 2 minutes to end the show.
No problem. We need to tread cautiously. This call is utterly reckless and should not be countenanced. Chairman Asedun Ketia, I love you, I respect you, and I appreciate your presence and politics. You've added a lot, but this one is a takeaway from your legacy.
Thank you.
Not to be repeated.
Thank you very much. Richard Ahiagba is Director of Communications for the opposition New Patriotic Party. Elia, Hamza, no reaction here. No. Hamza.
Security
Hamza,
in elections.
Hamza,
Whose duty is it?
Hamza, we need
the
to
Electoral
wrap up.
Commission or who?
Hamza, we need to wrap up. It's already 12. We didn't even have time to discuss the MPP internal election because of this. Is what we draw the curtains to.
That's the intention from the
Gentlemen. So you heard Richard Ahiagba, Director of Communications for the MPP. Hamza Suwini, a member of the NDC communications team, and the Apia Dankwa, spokesperson for Movement for Change. On Zoom was Franklin Kujo, president of Imani Africa. My name is Sami Wiafe. I'm starting for regular host Salom Adonuke. So we'll come your way again next week. May the good Lord be with us all.